Rise. Justice of the Appellate Division, Supreme Court, First Department. We hear you, all persons having business with the Appellate Division. Draw near to your attendants and you shall be heard. Please be seated. Good afternoon. And welcome to the Appellate Division, First Department. Most of you know the drill. We will begin with the call of the calendar. And I'm going to ask you, please understand that the bench is familiar with your case. We have read the briefs, looked at the record, and know your case. So please ask for the time you actually need, not the time that you want, so that I don't have to do it for you. We have 6 hours of requested argument time, and no one wants to stay here 6 hours. Okay. People versus Kai Watkins.
For appellate, 7 and 2.
Okay.
For respondent, 7.
6 and 2 and 6. And please remember that the time the court gives is the time for you, not for us. So if you argue in a way that causes us to have more questions, we can go beyond the light, so don't get distressed by the number we give you. Castaldo versus Manhattan Mini Storage.
Good afternoon, Your Honor. I'll request 5 and 2, please.
Okay.
Good afternoon, Your Honor. Respondent's request 4.
4 and 1 and 4. S. Floor versus Luis R. is submitted. Truesdell versus Roman Catholic Diocese.
Your Honor, I'll request 5 and 2. And respondent 5, Your Honor.
5 and 2 and 5. Thank you, gentlemen. Joyner versus City Car Leasing.
Good afternoon, Your Honor. I'll request 5 and 2.
Okay.
Respondent request 5, Your Honor.
All right. 4 and 1 and 4. Videla versus City of New York. Submitted. People versus Brian Abreu. Submitted. Denenberg versus 268 West 47th Street. 5 and 2 and 5. Saw versus Mayor's Office of Housing. Okay. 5 and 1 and 5. Countrywide Insurance versus Aguilar. Submitted. People versus Jose Torres.
Good afternoon. For appellate, request 4 and 1.
No respondent? How much time do you want?
I have 4, and there's no questions.
Okay, 4 minutes. Estrella Duarte versus Rachel Cho, Inc. Submitted. Vasquez versus Strickland. Submitted. Christian versus City of New York. Submitted. Velez versus Mitchell. Okay. Six minutes? Okay. 6 and 2 and 6. New York Presbyterian versus New York City Water Board.
Your Honor, appellate request 5 and 1, please.
Okay. 5 and 1 and 5. People versus Jeremy Sanchez.
Good afternoon. Appellate request 6 and 2.
Okay.
People request 8 minutes, Your Honor.
Okay. 5 and 1 and 5. McKeon versus Musaliam.
Good afternoon, Your Honor. Appellate request 5 and 2.
Okay.
Good afternoon. Respondent request 5.
Okay. Got it. Okay. 5, 2 and 5. Flowers versus Cora Realty is submitted. First case on the calendar, People versus Kai Watkins. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the Court. Marika Meese for Appellant Kai Watkins. I intend to address points 1 and 3 in my brief, unless the Court has any questions as to point 2. Turning to point 1, the people failed to meet their initial burden at the suppression hearing by providing that the arresting officers had probable cause to arrest Mr. Watkins and providing uncontested firsthand evidence to the hearsay of his actual arrest.
What about Mr. Watkins' statement, counsel, at the suppression hearing that he was asked about Jonathan, and Jonathan R., of course, was his co-defendant, in the patrol car going back to the precinct? Doesn't that give rise to an inference that those officers had information, that Jonathan had given information that was inculpatory of your client?
No, Your Honor, because there was no firsthand evidence that information was conveyed to the arresting officers. The testifying officer that the people offered at the suppression hearing did not know who had arrested Mr. Watkins.
No, I agree with you on that. What about the inference?
I mean, it's a potential inference, but it doesn't overcome the people's initial burden in this instance, because they had to establish both that there was probable cause and because the circumstances of the arrest were contested, whether it was at Mr. Watkins' home or on the street. There was an additional prong that the people needed to satisfy to meet their initial burden. And so this isn't a case like the one cited by the people where there's a radio run that's broadcast and we know that the arresting officers heard that radio run and acted upon it. For the same reason, the fellow officer rule doesn't apply in this situation, because there was no indication that even if probable cause existed, that probable cause was conveyed to the arresting officers and that they acted upon it.
Counsel, do you know what time the defendant here was arrested, wherever he was arrested?
What time?
Yeah.
I don't know the exact time because the arresting officers never established that.
Well, what we do know is that in terms of the timetable, that we have Detective Connor, he spoke with Jonathan at about 2 o'clock. According to him, that interview lasted about an hour and a half, bringing it to about 3:30. And then we have Detective Connor taking a statement from defendant at about 5:15. So that leaves about an hour and 45 minutes, 2 hours for the information that Connor had to get into the hands of the arresting officers. Is there anything in the record that indicates to you how that information was transmitted?
No, that's the problem. There is no information showing that that the officer who may have had probable cause based on his interview with Jonathan actually conveyed that.
Now, there's no question that Detective Connor, based on the interview with Jonathan and Jonathan's IDing of the defendant, that Detective Connor had probable cause.
Correct. Detective Connor may have had probable cause based on the statement from the co-defendant and his implication of our client, except in the first statement, of course, he did not identify him by name, and then he identified him by a misspelled name, and they never offered the picture and evidence to show that he had, in fact, identified Mr. Watkins.
And is an inference that the arresting officers knew or were aware of this information because they made reference to Jonathan on the ride back to the precinct. Is that sufficient? And if not, why not?
It's not sufficient because that testimony came only from examination of Mr. Watkins in his suppression hearing testimony, and it was the people's burden to offer a witness who had firsthand knowledge of the actual arrest to overcome the hearsay and to meet their initial burden. As well, there's still a missing chain of events, and the inference alone doesn't get you there because you needed more to establish that either for Connor to say that he broadcast this information to officers in the street, or to show independently that the arresting officers had received it and were acting on it.
And I think you might have mentioned it, but as far as I can tell, there was nothing in the record that Detective Connor even knew the names of the arresting officers.
Absolutely. He didn't know the names of the arresting officers. He didn't know anything about it. He never testified that he conveyed whatever information he had that might have satisfied probable cause to anyone or to those specific officers. Turning just briefly to point 3, this is the point where Mr. Watkins was prevented from responding to the people's use of his Rikers phone call by evidencing his mental illness. And so in this situation, the people had opened the door by offering this evidence and offering it specifically to show that he had fabricated. And he was allowed only to testify that he had been taking anxiety medication and that the call was a snippet. but he was never allowed to actually evidence it with proof that he indeed was in a mental health housing unit, was seeing Bronx Link and other doctors. And so therefore, what the court permitted did not suffice to...
You concede that he didn't comply with CPL 250.10. You do concede that?
I do concede that, and it was not necessary here because he was never offering a mental health defense. What he was trying to do in response to the people having offered this call is to show that he was actually mentally ill and was exploring a defense he never pursued. Under those circumstances, because he never offered in any way, shape, or form a mental health defense, what he was trying to do was prove his testimony was an alibi defense, but the people were able to eviscerate his credibility with this Rikers call they relied on in summation that he did not have a fair opportunity to respond to and to evidence. So too with the court failing to instruct that the call was just a snippet. His testimony alone, again, wasn't enough because the independent statement from the court would have corroborated that and allowed him to fully present and explain in response. I see
Thank
that
you.
my time is up.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court, Lori Farrington for the respondent. Addressing
Also,
the
how did the arresting officers, what's their basis for probable cause?
basis for probable cause was the co-defendant's statements to Detective Connor inculpating the defendant and identifying the defendant as his accomplice.
How was that transmitted to the arresting officers? How was that information transmitted?
Your Honor, that is where the reasonable inference comes in. The defendant was
Are
not
you
a
expecting the
suspect.
court, are you proposing that you satisfied your burden based solely on an inference?
That we satisfied our burden to show that there was probable cause for the arrest, yes, to show the reliability
Well,
of Detective
probable cause is
Connor.
not at issue in terms of when it comes to Detective Connor, right? I think we all agree that the information that Detective Connor had does give rise to probable cause. The question is, what information did the arresting officers have at the time they arrested the defendant?
Yes, Your Honor, that is where the reasonable inference comes in, where officers from the same precinct, after defendant is identified by the co-defendant, which was their only evidence of defendant's involvement, officers from the same precinct went to the area where defendant resides and arrested him. Even the defendant himself
That sort of implies that they went there for the purpose of arresting him. I'm not sure that that's clear from the record, right? The defendant did say that he had had a prior interaction with an unpleasant one with one of those officers in the past, leading to another possible inference that they knew this defendant.
Well, defendant himself did not state that the officer, which was Detective Elio, that he allegedly had this encounter with, was one of the officers who arrested him. According to the defendant himself, he did not see Detective Elio until he was in the precinct. And according to defendant himself, the officers were very clear that they were there to arrest him for the robbery of a cab driver committed with Jonathan. The defendant himself did not contest the probable cause of the officers. The defendant conceded that point and stated that the officers told him, it's a robbery with a cab driver. Who's Jonathan? 3 days ago. So that point was actually not at issue. So yes, it is a reasonable inference, given these facts and this testimony, that after the co-defendant inculpated and identified defendant, that officers...
So are you resting our ability to make this inference based on what the defendant said?
No, Your Honor. Based on Detective Connor's testimony, based on...
The problem is Detective Connor does not testify that he transmitted this information to the officers who arrested him, and as my colleague pointed out, didn't even know who arrested him.
That is correct, Your Honor. And again, that is the reasonable inference, that the officers from the same precinct...
But I don't understand why we need a reasonable inference when you had the officer on the stand, Detective Connor, who had the probable cause, and could have relayed on the record to whom he conveyed this information in order to affect the arrest. Why is that so hard, and why is that so unreasonable for us to expect that that be a part of the record and that we not have to do mental gymnastics in assuming an inference?
Well, Your Honor, it's not mental gymnastics given these facts. And
Well, to me, the only thing that makes it not mental gymnastics is the defendant's statements at the time of the arrest, which is why I thought you brought them up.
Your Honor, the defendant's statements at the time, the defendant's statements at the hearing show that he was not contesting the probable cause of the officers arresting him. And we met our burden of going forward to show the aspects that we were required under the law to show.
Counsel, are you saying that you met your burden of going forward without the defendant's testimony?
Yes, I would.
So without the defendant's testimony, how do you get the information from Detective Connor to the arresting officers?
Again, Your Honor, that is where the reasonable inference comes in.
Right, but your reasonable inference is based on what the defendant testified to. And what I'm asking you is, without that information, how do we draw that inference? Based on what?
Again, Your Honor, the fact that the defendant was not known to any of these officers as a participant in this robbery until the co-defendant implicated him and identified him to Detective Connor at the 4-5 precinct, after which time the officers from the same precinct went and arrested the defendant. That is where the reasonable inference comes in, Your Honor. There was no other, Kai Watkins was not known to them as a suspect in this robbery until the co-defendant told Detective Connor, this is who I did this robbery with, here I'm identifying him as Kai Watkins, and then the officers from the same precinct went and arrested him, and that is the reasonable inference. Defendant's testimony further supports it, but Detective Connor's testimony establishes the reasonable inference that the hearing court drew.
Is a reasonable inference enough to meet your burden of going forward in the first instance?
Yes, given that we met our burden to establish the probable cause, to establish Detective Connor's reliability, and to establish the basis of his knowledge. The reasonable inference only comes in where the court drew that inference that Detective Connor imparted this information to the officers from the same precinct who arrested the defendant. That's the only piece of inference the hearing court drew.
And is that the only reasonable inference that could be drawn from this set of facts?
Yes, the only other inference is that officers from the same precinct coincidentally went to the area around
Not coincidentally, defendant argues that he was known to this precinct.
Yes, but the testimony of Detective Connor is what established his participation in this robbery, and co-defendant Jonathan's written statement, which went into evidence at the hearing, establishes that it was Kai Watkins, that was the basis for their knowledge. Otherwise, we coincidentally have officers stopping Kai Watkins because another detective in the precinct allegedly had an encounter with him. And coincidentally, he happens to be identified by the co-defendant in a
Do these
written
facts
oral
give?
statement.
Are you saying that the only reasonable inference here is that the information that Connor got was imparted to the arresting officers directly or through other officers? You don't even know that, do you?
No, Your Honor, but the fact that it may have been imparted through other officers certainly does not mitigate the probable cause here, nor does it mitigate the reasonable inference.
So, but in that case, wouldn't it be important to know exactly what was imparted to the arresting officers?
Again, Your Honor, that is where the reasonable inference comes in, and according to the case law...
I got it. We have gone way over time.
We have, Your Honor.
and we're going over it a second and third time.
Okay, since my time is up, I'll rest on our brief for the other points. Thank you.
Thank you. Counsel, you got 2 minutes on rebuttal.
Thank you, Your Honor. This is the people's burden at the suppression hearing, and as they indicated, the only way they can really meet that burden is through Mr. Watkins' testimony that the hearing court rejected as incredible and that they urged.
Hold on. Counsel, the argument is not over. You should be at counsel's seat. No problem.
And the respondent argues that the suppression court rejected Mr. Watkins' testimony entirely, but yet we're supposed to credit that and somehow find that they made their burden through his testimony.
But what is the burden of going forward? What exactly does that entail?
In a situation, I'm sorry, take my mask off. In a situation like this where Mr. Watkins has contested through a Dunaway hearing the hearsay information offered and the probable cause for his arrest, they have to demonstrate both through non-hearsay evidence, through firsthand showing that the arresting officers seized Mr. Watkins based on probable cause conveyed to them. So here in this situation where Mr. Watkins contested it, as he did in his motion and in cross-examining the officer and by testifying himself, Gonzalez and other cases required that they actually bring forth that information, showing they had probable cause and showing that the arresting officers had non-hearsay information as to who arrested him.
Counsel, how do you respond to your adversary's contention that the defendant admitted that the officers told them that they were there for a robbery and asking him whether he knew or was familiar with Jonathan?
That was in his hearing testimony, but elsewhere he contested the probable cause for his stop and the Dunaway portion of the hearing. So that doesn't overcome or meet the people's burden. And as I just noted, the people...
But doesn't it beg the question that if he indeed made those statements, then obviously the officers who arrested him had that information and would have had to have that information from somewhere?
That is one inference, but I don't think it's established, and it's not enough to meet the people's burden. And again, his testimony can't be the sole basis on which the people rely to meet their burden. They had an officer on the stand who supposedly had interviewed Mr. Jonathan and obtained the probable cause. He could have testified that he conveyed that to other officers in the precinct. I don't even think it's clear in the hearing record that other officers from the same precinct arrested Mr. Watkins. It could have been other officers from somewhere else entirely who then brought him to that precinct because they found, when they looked up his name, information that there was an iCard.
Well, your adversary kept on arguing throughout her argument that officers from the same precinct arrested this defendant. Do we have that established on the record?
No, it is not established on the hearing record at all. So that also creates a problem in this inference because we don't even know that they were officers from the same precinct who might reasonably have had that information.
That's another inference we're supposed to make.
Correct, according to the people.
Thank you so much.
Thank you.
Castaldo versus Manhattan Mini Storage. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Scott Horn, counsel representing the appellant in this matter. It's our contention, Your Honors, that the motion court erred in awarding summary judgment to defendant because the competing expert affidavits engendered a classic tribal issue of fact regarding the building code violations alleged. Now, in moving for summary judgment, the defendant submitted an expert affidavit which appears at page 726 in the record. And if we look at page 726 in the record...
Am I wrong that the basic thrust of this case is that as a result of the wet stairs, he slipped and fell?
That is correct, Your Honor. So it was a combination of wet and construction debris as well that became wet as a consequence.
Counsel, did he fall on the stairs or on the landing?
He fell from the platform down the stairs. So if you're looking at the stairway from the top, top step, for lack of a better term, is the platform, and then it goes down each riser. So he
counsel,
slipped, pardon me, Your Honor?
Plaintiff's experts didn't do any slip-resistant testing, correct?
I'm sorry, I missed that, Your Honor.
Plaintiff's expert
Yes.
failed to do any slip-resistant testing on the platform.
Yes, that's correct, Your Honor. But the reason why the no slip-resistant testing was required is twofold. Number one, we've alleged and established via our expert that there was a building code violation as a consequence of not having the platform surfaced with non-skid materials, meaning crosscuts or abrasions on the platform or things of that nature. That's a building code violation. that was
Counsel, it's a
alleged.
building code violation if the steps are considered to be interior stairs, correct?
No, that's not correct, Your Honor. And that's part of why I take issue with the way that the lower court accepted the defendant's expert and rejected the plaintiff's expert as a matter of law. So when you look at the defendant's expert, he opined in the third full paragraph, very conclusory, Your Honor, in response to a previous expert disclosure regarding the violations, he simply says the subject's stairway was neither an interior nor an exterior stair as per the 1968 code. That's it. There's no analysis of the statute. There's no analysis of the situation, the stairway. That's all he says.
The
So let's even
violation would be irrelevant if, as a matter of law, defendants win on the issue of notice, correct?
The building code violation would not render notice irrelevant, Your Honor, because if there's a building code violation, they've affirmatively created the hazardous condition. It doesn't become an issue of actual notice or constructive notice.
But
They've
then you would have to establish that the alleged building code violation by itself, without the water, could have caused this accident, and I saw nothing to that effect.
Well, now you're talking about proximate causation, Your Honor, and granted, generally speaking, that's something that's left for the fact finder. But here we have two competing expert affidavits. One is saying this
Yes,
building-
but one does not at all deal with the issue my colleague noted, which is the notice issue.
Well,
That
again,
he had been in the storage unit, if I recall correctly from the record, about 45 minutes, perhaps tops an hour. And based on the case law of this department and probably almost every other department, 1 hour is insufficient amount of time for a landowner to remedy any situation of water, gathering, et cetera. Am I
But we're
wrong
talking-
about that?
Sure, we're talking about two different theories of liability, though. One is the failure to adhere to the building code, and the second is this transient condition that caused him to slip and fall along with the violation of the building code. So we have two different theories of liability.
Again, I don't recall seeing in your expert affidavit that this accident would have happened even without the inclement weather, which would be required for us to get past this stage on just that theory, as you suggest. But you're out of time. Think about what I've just posed, and you can respond to that when you come back.
Thank you, Your Honor.
You are welcome.
Good afternoon. Thank you. Good afternoon, Your Honors. I think the panel covered the notice issue. I think 45 minutes to an hour really isn't sufficient time to have remedied this condition.
I have a question as to where the accident took place.
So if
Did he slip and fall on the landing, or, as your adversary just stated, he slipped and fell on the stairs and ended up on the landing?
on the landing, Your Honor.
That's my understanding, that he slipped and fell on the landing, and that's according to the record at 185. So to what extent is there diversion of opinions, of expert opinions, to the extent that there was only one, what is it called, slip-resistant test, wet dynamic slip-resistant test, and that's the one that was done by the defendant's expert only?
Correct. So you have as you can envision it, if you can, you're walking out and you're stepping out onto a landing, and then there are 4 steps going down. And the test was conducted by a respondent's expert, Mr. Patera, of a...
But am I correct that that test was conducted after the defendants here changed the condition of the stairs?
I think that's a misrepresentation on the part of appellant, Your Honor.
So the condition that was tested by your expert was the same condition present on the day that this plaintiff fell?
Right. The plaintiff's brief is very careful to avoid drawing a distinction between replacement of the steps versus replacement of the ladder. So treads were put on the steps, but the landing was never altered. It was the same gray paint. It had been since the date of the accident to the date that both appellant's expert saw it and respondent's expert saw it.
Okay.
Unaltered.
And the defendant's expert found that the landing contained a slip-resistant surface, am I right?
I can't really recall specifically without reviewing the report and the affidavit, but the finding was that it passed the slip-resistant test, whereas there
Even
was
if it was in a wet state?
Correct. That's right. So this spoliation argument in the plaintiff's brief, appellant's brief, is just, there's nothing to exfoliate it because the landing never altered. It was never changed. So there's no cause and create. There's no notice, no actual or constructive notice. Therefore, Justice Kotler made the right decision in respondent's view.
What about, I'm sorry.
Go ahead.
What about the response that was given to a question posed by my colleague that these were not exterior stairs, that these were neither interior nor exterior stairs?
I mean, a violation of the
I
building.
saw the picture of the photograph. It looked
Right.
like it was outside.
Yeah, they're outside but covered. So
And does the fact that they're outside suffice to make them exterior stairs as opposed to interior stairs?
yeah, they're subjected to the elements, so they're exterior stairs.
Okay, thank you.
Thank you.
Very briefly, Your Honors, at page 752 of the record, at the bottom is where the expert deals with the issue of causation, and it is a paragraph that talks about the non-code compliant features as discussed above was a substantial factor in the cause of the slip and fall. So I think that as far as proximate cause is concerned, which again is inherently a triable issue of fact, you know, I think that we've met the burden to establish that here. And in fact, that wasn't the basis for the lower court's determination. The basis for the lower court's determination was rejecting one expert while accepting the other. As far as the coefficient of friction testing, that's a bogus test. This is a test that their expert took 2.5 years later, and their own manager testified that the stairs and the floor had been painted numerous times. In fact, he specifically testified that those floors are
Counsel, I go back to the same question. You're referencing the stairs, but didn't your client fall on the landing?
He fell on, he slipped on the landing and fell on the stairs. So if you look at pages
So if
201.
he slipped on the landing and fell on the stairs?
Fell down the stairs, yeah. Yes, so it's the top step, essentially. He slips.
I know, I've walked downstairs. We all
Okay.
have. Thank you.
So pages 201 and 202 specifically talk about him slipping on the landing, and then he slipped, he braced himself to protect his head and fell down the stairs. And it says all of them, he says no about midway. So it was a flight of stairs that he fell midway down as a consequence of slipping at the very top of the stairs as a consequence of the building code violation.
Thank you.
Thank you, Your Honors.
Truesdell versus Roman Catholic Diocese. You may proceed.
If Your Honors, please, my name is Ed Guardaro. I represent the appellant. I would submit to the court, Your Honors, that the second and third prong of the cause of action for negligent hiring supervision isn't made out. And there are two issues here. One is one of duty. The claims in the complaint actually don't make out facts, which would trigger a duty. And number two, they don't trigger a nexus. So as the court understands, this is 1963. There's a single accident, or a single attack, excuse me, which occurs at an undisclosed place in a different borough than where this church is. And this is the province we're talking about. I'm representing the province. I would submit to the court that while the liberal pleading standards in New York are what they are not limitless under this court's determination in Nagel, and then years later in Doe versus Goldweber, and then moving forward, and then even in the Second Department in the J.D. versus Archdiocese case, most recently in 2022, the courts have all articulated, this court included, have all articulated that there has to be the facts have to indicate or demonstrate a duty, that there has to be a fact underneath the allegation and not just speculation. I would submit to the court that what we have here is just pure speculation. The words are stated, knew or knew of, or conspired or covered up. The words are there just as they were in Nagel, just as they were in Goldweber, just as they were in J.D., but there's no facts to support that. Now, it's not a question of showing, it's just a question of making the allegations based on fact.
So could you parse your understanding of what a fiduciary duty is, given the fact that there was a minor here who alleges the sexual abuse by the priest? I know that in Marmelstein, there is a distinction made between the viability, and I'm quoting, of a civil action premised on sexual contact between a cleric and a person who is incapable of consent, such as a minor.
Yes, Your Honor, I'll address that.
How does that apply here?
I'm sorry?
How does that apply here? What's the difference?
Okay, I would submit it does not apply under the circumstances. The age of this particular individual, the victim, plaintiff, I would submit doesn't necessarily apply at all, even under Marmelstein and the cases upon which it cites to. The age, I say that for a good reason, and that is that because the victim in this case was under the control and custody of his parents at the time of the attack, and in Marmelstein and these others, they were not. They were under the control and custody of those attackers. So that's number one. Number two, it has to be.
I don't understand that argument.
Understand that at all.
This child is taken somewhere by this priest. He is not with his parents, so he is not at the moment under the control of his parents. So what are you talking about?
So under
At the time of his attack, he was with a priest who abused him. So how is he under the control of his parents?
At the time that the plaintiff left with the attacker, he was at home.
Right. His
in the
parents
custody of his parents.
Trusted this priest and gave permission for this child to go with this priest.
Correct.
Got it.
In Mermelstein and in all of the cases upon which it relies, which are federal cases interpreting Connecticut law, the situation was much, much more.
Right. In Marmelstein, we had an adult woman.
Correct.
Totally different.
Correct. So my point is, on a fiduciary duty, where the courts have all said de facto control and dominance, it has been in situations, and that's in Federal Insurance versus IBM.
Doesn't the priest have the de facto control and dominance here? I don't understand you at all.
Because the situations are, Your Honor, I would submit that under the circumstances of all of the cases which talk about this issue, and especially J.D. from the Second Department, which is specifically on this case, it specifically talks about control. So for instance, in J.D., the child was attacked while in the school, at school premises, in school classes by school employees. So, and in that case, the court said there can be no fiduciary duty. In Mermelstein and the other cases, again, citing to Connecticut law, they talk about the same kinds of scenarios. They're in the custody and control of the attacker. So here, we have a situation where the person is, the victim, is not, when they are attacked, in the control of the province. They're certainly not in control of the province. If at all, they're in control, as Your Honors have stated, of the attacker.
This is
Also, is it your position that the province would have owed the fiduciary duty if the allegation was that the priest removed the child from the church?
No, Your Honor, because it's outside the scope of the duty. All of the cases say that you can't have a fiduciary duty for vicarious liability.
So based on what you just said, there is no circumstance under which a church could be held liable, because at no point would a church say, yeah, we told the priest, go ahead and sexually abuse these children. So we're never going to get that. So you're saying unless we have that, there's no liability?
No, Your Honor, this is a 3211 motion to
I
dismiss.
know what this is.
So there can be situations in which fiduciary duty might be found as an issue of fact because of the circumstances of that case. There are circumstances in CVA cases, right, where it's not an employee, it's the church itself. There are allegations that the governing body people were the actual attackers.
So you're saying if an individual priest in a church abuses a child in the church, or takes the child out of the church and takes them somewhere to abuse them, under those two scenarios, church is scot-free.
Your Honor, I'm not saying that. J.D. versus the Catholic Church of Diocese of Brooklyn said that in 2022, the Appellate Division Second Department, they said that when the child is actually in the custody being attacked by the priest themselves on the property, there's no fiduciary duty. So one step beyond that, when the attack occurs far away in time and space from any property owned or controlled.
And your argument is that we should adopt that Second Department reasoning, which we are not bound by, obviously.
Obviously, Your Honor, yes, but I believe it also emanates from the de facto control and dominance issue of all of the other cases addressed.
I can't buy that. I have to tell you, I just can't buy that. If you want to make it a different argument, I'm willing to listen, but you're saying that this child remained under the control of his parents while, I mean, you look at the history of this, of the relationship between the child and the priest, where he was favored by the priest, perhaps some would say groomed by the priest, and then you're saying that doesn't count? The fact that there was trust placed in all of these institutions? I mean, make a different argument.
Well, Your Honor, I can make a very simple argument. It's duplicative of negligent hiring, supervision, and control. That's also in all of the cases which this court and other cases have all said. It's duplicative. So there's another grounds upon which...
So you agree that the province can be held liable for negligent hiring and supervision? It wouldn't exactly be hiring, it would be more assignment.
I didn't get the other part of it, Your Honor.
You agree that the province, the Dominican, what is it, the Dominican province of St. Francis?
St. Joseph.
St. Joseph, sorry. That you agree that they can be held liable for negligent supervision?
Not under the claims alleged here, Your Honor, in the complaint. As a general proposition, could it hypothetically happen? Anybody could be, but under the claims articulated in the complaint here, no.
Okay. All right, you'll have time on rebuttal.
Thank you.
You may proceed.
Thank you, Your Honors. May it please the court. My name is Rick Kroger. I'm here on behalf of Respondent Glenn Truesdell, who was 11 years old when he was sexually abused by this priest. And I believe that the court has begun to see the issue that appellants are trying to hide behind. They appear to
Well,
be...
if your friend is correct that JD from the Second Department is the governing standard, would your pleading satisfy that standard?
I believe that JD says under those specific circumstances of JD, the court said that a fiduciary duty did not exist was not alleged.
But they adopted a test from a third department case that indicated that a religious institution would not owe a fiduciary duty to an individual unless the plaintiff, the individual, could plead and prove that there was some special relationship between the institution on the one hand and the victim, if you will, on the other.
Yes, and I believe that at the very least, we have alleged that in at least one paragraph when we have specified that our client was an altar boy who was trained by priests.
The problem is there are a lot of altar boys.
Yes, Your Honor.
So how does his being an altar boy set him apart from all the other altar boys, right?
Yes, and I think, Your
Or
Honor.
are you saying that category, altar boys, is a special category that in and of itself establishes a special relationship?
I have not seen any opinions that say that status as altar boy in and of itself makes a person, puts them in a special category, and I'm not trying to suggest that the law says that in New York. What I would say, Your Honor, though, is that when a child is placed into altar services and trained by priests as to what to do during church, I think that very well, under the factual circumstances that are yet to be fully developed in this case, which is still on a motion to dismiss with no discovery, those facts might bear out. It may very well be that Mr. Truesdell, when he was 11, had been taught by Father Zulian what altar boys do, and those facts are parts of the facts that will come out. I think that
aren't we? We're not talking about the church on this motion. We're talking about province. So now they are one, if you will, one link in the chain removed. You have the church, and now you have province, and there obviously is some relationship there. But we're not talking specifically about the church on this motion. So with respect to breach of fiduciary duty, I want to first of all get not to pin you down. You can elaborate later, but yes or no? Do you agree that we should apply JD's standard?
yes, in the sense of the standard, not in the sense of the facts alleged.
So you believe that it is the appropriate legal test on the breach of fiduciary duty in this context is that the plaintiff has to plead and prove that there was some special relationship between the religious institution on the one hand and the victim on the other?
Yes, Your Honor.
Okay.
We acknowledge that, and we believe that we have alleged that sufficiently, given that this is something that the court hit on already in questions, was that this person was not actually in the control and custody of his parents. This person was given to a man, not a member of the family.
I know, but there's no question in terms of the case against the individual priest, right? There's no question about that. And I think that there's certainly issues to be made about the church, right? Which is right there, is observing what the priest is doing, his daily activities, etc. But how do we connect the province, which is removed? They're not at the church. They don't see what this priest is doing on a day-to-day basis. How have you established that as to the province?
Your Honor, the province is the defendant. They are responsible for making Father Zulian a priest who then can be assigned to the church, which gives him access to these specific children as opposed to some other children.
Got it. So if there were allegations in this complaint that said this father had been removed from another church for the same thing, and he comes to New York and you put him right again with children, do I have that here?
Well, Your Honor, part of the problem is that appellants would like for us to have full discovery before we even make our complaint. They are trying to force the cart before the horse by saying that we have to prove exactly when and where and how they gained every aspect of notice, and we have to file that in our complaint. And I think that is far removed from the actual standard, and I think that our complaint does, in fact, allege the necessary notice and demonstrates that they should have known that Father Zulian was going to use as, if I may, like this court said in Gonzalez, the province, much like a police training department, the province put the faith, the priest, made him the person that a parent would give their child to. They would not do this to some stranger on the streets.
I want to ask another question, if I may. So counsel, is it possible to define or describe the relationship between the priest and the province without discovery?
To a certain extent, yes, because we know from official Catholic directory, which is part of the record, that he was in fact a priest of this parish. So we know that he is their employee. We know where he was
I'm
assigned.
asking about the province, not the church.
The official Catholic directory lists Father Julian, and it's in the record, as OP, which demonstrates which province he is a member of, who employs him, who has control over him, because his designation, importantly, never changes when he goes to a church in Brooklyn or the Bronx or Philadelphia. His designation as an OP doesn't change because the province is the organization that gives him, that vests him, literally vests him with priesthood.
Did you plead in your complaint that either your client or his parents were even aware of the existence of the province?
We do not, I don't recall if we alleged their knowledge of the province, Your Honor. I don't believe we had to be honest.
Thank you.
Thank you.
You have 2 minutes.
Thank you, Your Honors. If I may address some of the court's concerns, I would submit JD is very relevant. There are no special circumstances here. As Justice Maisonnette pointed out, it's very difficult to simply say that every altar boy creates a spectral relationship. These are very, very hard cases. I understand that. These are very difficult scenarios.
And our questioning is not personal, for the record, okay?
Absolutely, Your Honor. I understand that fully, and I absolutely understand.
In light of the fact that I think we could all agree that, and I think you did, sir, that the buzzwords, the technical legal words are in the complaint to state the cause of action. Maybe not to satisfy 3211A7, but the words are there. I think you acknowledged that in your opening argument.
Yes, Your Honor.
Maybe in light of the unique nature of this kind of case, which you're put into this position as a result of the CVA and facts that have occurred, or incidents that have occurred, crimes that have occurred a half a century ago are now germane. Would the discretion call for here allowing the complaint to go forward for the discovery because of the difficult position that all parties are in vis-a-vis access to the relevant information? Whereas normally we may not tolerate such conclusory pleadings, because here the victim was a child at the time, the passage of half a century. What more could they do with much of this than offer just the bare bones pleading to basically recite the elements?
Many CVA cases, and I'm sure Your Honors may have seen some of them, many of the cases have records, and in the complaint specify specific allegations. They are in the newspaper reports, they are in other factors, even cases from like this generation in 1963. So I do not believe we should relax those standards, because then I think you're getting into a very slippery slope on a policy issue. And in this case, where we have a retroactive applicability of the statute, there are records. In other cases, you'll see them, whereas they've proceeded past this dismissal provision. The defendants have not moved on every case, and they acknowledge that there are records, and they'll disclose those records. So we do not have to do that in this case, because if they were records, and you can see in the opposition papers to the court motions below, plaintiff took a lot of time and effort to try to go out and find those records. And if they could have, it would have been there. And we would not be here. Those records do not have to come through discovery. Plaintiff's counsel have been very, very aggressive and very articulate about taking some of these cases because of those records that they find or don't find. So I don't believe under the circumstances of this case that we should go down that road. I would also just want to point out that under Kenneth R., we spoke about the connection, just very briefly, the connection between, I think Justice Gonzalez spoke about, is there a connection between the province and this attack? And my adversary mentioned about how, and it's in the briefs, about how the ordination of a priest might create that connection. I would just submit to the court that under the finding in Kenneth R. from the Court of Appeals, that's specifically been rejected as a nexus on First Amendment grounds. So thank you.
Counsel,
Go ahead.
But counsel, isn't Father Julian Zulian, sorry, subject to the discipline of both the diocese and the province?
I would be total speculation. I couldn't answer that one way or the other, Your Honor.
So would that be within the, would that be within the parameters of discovery? There's so much information here that is unknown.
Right.
Just so much information, and as at least the newspapers tell us, so much information that was hidden. Doesn't this properly fall within the ambit of discovery?
Well, Your Honor, the other cases say no. Excuse me. The other cases that we cited to articulate that no. The answer is no. And that's why I mentioned Kenneth R., because Kenneth R. explored all of these different parameters and all the possibilities of the connections and agreed with plaintiff on some, agreed with the defendants on the other. But when it came to the connection as to the real hard and fast connection, they found that was not only too tenuous, but it was undermined by the constitutional rights of the defendant.
Thank you.
Thank you, Your Honors.
Joyner versus City Carter Leasing. You may proceed.
Good afternoon, Your Honors. Greg Friedman for Appellant. So it's pretty simple. What the defendants are essentially arguing is that if plaintiff wants help now, they have to run to the bankruptcy court to get it. I think they have it totally backwards, at least as far as City Carter is concerned. There was never a stay that applied to them in the first place.
It's automatic by operation of law.
It's automatic as to the debtor, who is the driver.
Counsel, it is automatic that any actions pending before the court are automatically stayed upon the filing of a bankruptcy petition.
As to the debtor, we cite those cases at length in our brief. If this case only involved the debtor, Chacon here, then yeah, maybe the quickest, best course of action, they go to the bankruptcy court, they apply under 362D, they get everything retroactively validated, and they could at least recover to the extent of the insurance policy. But when you have a non-debtor defendant, they are the ones that have to affirmatively seek the stay. I mean, this is extremely...
Do they have to do that if their liability is vicarious only?
They still have to do. That's the argument that they could have and should have made back in 2015 when the bankruptcy was filed. Now, of course, nobody knew, so they didn't do that. But that is not plaintiff's problem here. So we should not have to go to the bankruptcy court to get a stay annulled as to City Carter that never existed. That is the argument. And whether they could go to the bankruptcy court and get a retroactive stay, which the cases say you can't do, it's really not our problem or this court's problem right now. That's the distinction here. Again, there's a non-bankrupt co-defendant. They have to affirmatively and timely move to have the stay extended to it. Where is the case law authorizing any court, much less the state court, to give the non-bankrupt defendant retroactive stay protection? Doesn't exist. Where is it in the bankruptcy code? Doesn't exist. And that's why we say that the trial court had it backwards here. I think their decision focused entirely on the debtor himself. It said nothing about City Carter, and this really is not new law. The cases are out there. It does not extend to co-defendants unless they asked for it. And even then, it's a matter for the bankruptcy court, and it's discretionary. I know they raised this, well, okay, so we're going to go after the driver for indemnification. Okay, that's the argument that they should have made before. Now, the driver's already been discharged, which would become their problem. And this isn't unfair to them, right? This is why you have joint and several liability. It's to allow a plaintiff recourse to a financially responsible defendant. That's exactly what should happen here. So for those reasons, I think the trial court got this seriously wrong. If there are other questions, I'm happy to sit down, but...
Thank you.
Thank you.
it please the court?
Why is he wrong?
He's wrong on a number of fronts, Your Honor. First of all, as you mentioned, the stay is automatic. It's federal law. You don't have to do anything. You don't have to apply for anything. It occurs. It's triggered automatically.
As to the debtor,
Well, as to the debtor, but the stay, the 362 stay renders all actions, judicial actions that took place after the filing of the bankruptcy to be void. And in this circuit, and in this court has affirmed, the Second Department has as well, and the Southern District has as well, it renders every judicial action taken after the stay to be void. And what happened here is, now there's an extended period of time that nobody knew about this bankruptcy, and it's unfortunate and regrettable, and it's an unusual
Well, your
fact.
client knew, right?
I didn't hear you, Judge.
Huh?
I didn't hear what you said.
Was it your client who knew?
My client knew. He was represented by counsel in the bankruptcy court. He knew. He didn't file anything about the Joyner case. And when my office tried the case, there was nothing in the file about it. Nobody knew. And he gave a factual affidavit as to his reasons and what happened, and it is what it is. But the fact of the matter is that the trial that took place was violative of federal law. And the verdict that was rendered was violative of federal law, and the judgment that was entered on that trial was violative of federal law. Mr. Chacon testified as a defendant in that trial, which is absolutely prohibited under the federal bankruptcy code. And so a verdict was returned, and now the argument is that only some portions of this trial should be credited. Mr. Chacon is entitled to another trial. So what's being urged here is that another trial take place, but the previous verdict be held to be intact with respect to a co-defendant, which would open a Pandora's box of inconsistent verdicts, totally judicially unmanageable and wrong.
I mean, I guess it would be unmanageable, too, if we were only alerted about defendants' bankruptcies after cases went to judgment, and then were put into this position with some frequency. That would represent quite a waste of judicial resources.
I can't argue with that. It was a regrettable situation factually, and a lot of resources were spent on both sides of the V with respect to this. I think that
Well, I think what my colleague is asking, and I don't want to put words in his mouth, but that there's a perverse incentive here for defendants to not disclose their bankruptcy. Is that something that's going to happen?
Judge, I can't speak to that, and the circuits have addressed that differently. Some circuits, and those circuits are relied upon heavily in the appellant's papers, have said that such actions that are taken in violation of the stay are voidable, and they give their courts a certain amount of equity jurisdiction.
We don't
Not
have
here.
that. No, that's conceded here in New York. But I don't think there is a perverse incentive myself, because it seems like if you're a defendant and you go into bankruptcy, if you can avoid liability in a tort case, you're going to do that.
It certainly didn't benefit Mr. Chacon. I agree completely. He would have been in a far better situation if he had disclosed it, if his attorney had taken a more aggressive stance and put everybody on notice. It didn't happen, and that is why we're here.
Thank you.
Justice Moulton was putting words in my mouth, but they were better words.
You have 1 minute.
Sure, I'll try to make this.
No, you're gonna make it. You have 1 minute.
I will make this quick then. Number one, you're right, this put everybody in a terrible position. But plaintiff in a bad position, puts the court in a bad position. Number two, the cases that they cite about an automatic stay, they involve one defendant, the debtor. We're not arguing with that. We have a completely different situation here. And the cases that we cite on this point, they basically don't address because they can't. Number three, my adversary mentioned Chacon testifying at trial. There was nothing wrong with that. The state prevented anybody from recovering against his own assets or his estate's assets. Would it matter if he was called as a non-party witness? It doesn't. The overall point remains the same. There's a non-debtor co-defendant. There was never a stay. Nothing authorized the trial court to extend it to them 6 years after the fact. And
But under the circumstances, sir, how do we separate the proceedings out, given the relationship between the debtor and non-debtor?
Yeah. I kind of figured that question would be coming, and I don't think that you would have to here, because that's the exact argument that City Carter should have made assuming they had learned of the stay in the first place, that we're intertwined, there's vicarious liability, we could go after him for indemnification. But the law is still the law, that they had to seek that relief, and now that Chacon has been discharged, they can't do anything against him, and that's just in accord with the state's public policy. Otherwise, you're punishing plaintiff, and I mean, that point is obvious. So if there are no other questions, I'll rest on the briefs.
Thank you.
Thank you.
Okay. Denenberg versus 268 West 47th. You may proceed.
May it please the court. Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant in this case. As you know from reading the briefs, not only was my summary judgment motion denied, but I actually lost summary judgment on a case that I think is a very, very, very strong dram shop case on the facts. First point is wholly procedural. It's very difficult to get summary judgment as an affirmative event when you don't put on any witness or you don't have any evidence. And the defendants, for reasons that I really can't quite grasp, didn't put on any evidence because they said they didn't have any records. Now, my adversary is going to say to you, well, we got shut down in COVID. And that's true. And look, everybody knows what COVID is, except my client sent a preservation letter way pre-COVID, and the district attorney's office sent them a subpoena for the records, so there's no reason that they don't have the records. And the trial court's decision, at least as I read it, or at least as I see it, faults me for not being able to point to a specific instance where my client was served with alcohol by a specific waitress, even though I don't know one person who was there because they never gave me any of the records. So as a procedural matter, it seems completely unfair for me to lose
And we
summary
know
judgment.
that Run the City, the party promoter, did not have a liquor license, right?
Yes,
They can't
of course.
provide alcohol.
Of course. So one of the arguments that was made below, and I think counsel presciently didn't argue it here, was, well, we didn't do anything. This was a promoted event, and we're not responsible. Well, first of all, that's impossible because the liquor was theirs. Secondly, Hernandez said in his deposition that the bottle waitresses and the bouncers were paid by the Copacabana, and Mr. Desmond, who was the promoter, said, how could I possibly do that? I don't have a liquor license. I'm gonna get in trouble. So that argument makes no sense at all. And what we're looking at here is a situation where everybody, I mean everybody, you're talking about the driver, you're talking about his sisters, are saying that this plaintiff was blind drunk at 1 o'clock, and we know it was 1 o'clock because the sisters came there. You even have a video of him that was posted. I'm not sure what this means because I guess I'm too old to really understand it, but my bro lit, I think that means that he's lit up drunk.
Yep.
So Judge Manson, I'll defer to you on that. I'm not sure what that means, but this is a case.
I have young brothers, that's what it means.
Yeah, I should know it too because I have 2 young sons, but I just don't know what it means. But that, and they said he was drunk. Here's the other thing. If you read the affidavits of the owner, Giuliano, and you read Hernandez's affidavits, they support me. They want you to infer that there could never have been a sale of liquor to someone who was drunk. Why? Because they have this tremendous procedure where they don't, the word they use is overserve, and they go through these litany of checks that they have. Well, take a look at the evidence. The evidence 465 to 466 is the sister who said when they came up, there was an incident with the security guard where the security guard said he was drunk, and they saw he was drunk, and they still let him come up.
Well, so, sir, assuming we agree with you that as a matter of law, Mr. Troutman was visibly intoxicated, is there a tribal issue of fact as to who served him the alcohol? Or whether he was served by Copacabana at a time he was visibly intoxicated?
So my answer to that is no, because the testimony was that there was another bottle that was served to him which was never refuted. And I'm going to make it easy for you, Judge Higgett. I've got the lines to you. I'm not going to read it. 294 line 5 to 294 line 14. That's the plaintiff. His sister, Anaya, 472 line 5 to 472 line 18. the sister Shina, 512, line 22 to 513, line 18, and one more reference. This is also Shina, 518, line 19 to 519, line 24. I don't think that's disputed. And we also know that even though the claim was that there were only 2 bottles that were served there, there was more alcohol there. There was wine and there were beer bottles. So if the defendant's position is, I couldn't have done it because I didn't have any money, and that's a play on words. He didn't have money in his debit card, doesn't mean he doesn't have money. Where did the alcohol come from?
Thank you.
Thanks.
You may proceed.
Good afternoon. Thank you, Your Honor. Seabridge Johnson for the appellants, for the respondents. He just went. So I want to kind of go back to the Pretty Run the City, the third-party promoter that you're talking about. Giuliano, who owned the Copacabana, and also Mr. Hernandez both said that the bottle girls were actually employed by Pretty Run the City, that they brought their own staff, okay? That they were the ones who served alcohol throughout the night, okay? So at the very least, there's...
So aren't there a lot of issues of fact here? Aren't there, first of all, there's no receipts as to who bought what from whom.
Yes.
There's not even there's cash entry or an Eventbrite entry.
Right.
Right?
Right.
One side says, we don't have anything to do with alcohol. The other side says, they're in charge of the whole thing. This is a back and forth as to who was doing what, but the most noticeable part is the lack of documentation that one would normally have, such as receipts, how much alcohol was available that night, who was working. That's all non-existent. And can you really blame that on COVID?
Well, I would say that my client blamed it on COVID. I know that there's evidence that the letter came in certified mail, that somebody from Copacabana signed the letter and said, we got the letter pre-COVID. I'm not sure what the owner was thinking. What I do want to say is that if we actually take apart the testimony here that my adversary talked about, Mr. Trotman and his sisters both said that the 2 bottles of alcohol that came when he bought before the accident, right? The 2 bottles of alcohol that we know he purchased, he had 1 beer before he came, that's when the alcohol came, right? He was not visibly intoxicated at that point. Then we have Trotman, we have his sisters all saying, listen, he didn't go and request more alcohol, he didn't ask for more alcohol.
Yes, but they also said that upon their arrival at 1 a.m., he was already lit.
Right, but the 2 bottles were there at 11:30.
But also, China, counsel, I'm sorry to interrupt you, but
yes, sure.
You know, your opponent mentioned that China, one of the sisters said there were beer bottles, and that was not part of the bottle service that he received for his $300.
Sure, Your Honor, and I appreciate that point, but remember, this is a club with hundreds of people there. They're dancing.
Except that they were in a VIP section.
Right.
Counsel,
Yes.
the Copa, okay?
I haven't been, I've heard. Yeah.
Well, I have.
Okay.
And the VIP section, it's not a free-for-all.
Okay.
That is a cordoned off section so that people who pay the high prices for a bottle, because, you know, a bottle of vodka doesn't cost $150.
I sure
right?
hope not. Yeah.
But they pay $300 for 2 bottles.
Right.
So this is a cordoned off section. You don't have every single person in the nightclub going by these tables.
Sure. But also, and to that point, there's 5 other people in the section, right? Okay, it's not that, there's no evidence specifically attributing Trotman to these additional bottles of alcohol, to the wine, to the beer bottles. There's 5 other people and there's friends there.
Great, but how do you get summary judgment?
Like I said, I think the testimony is mostly speculative in that regard. I can see why plaintiff may have appealed, okay? I can understand on the issue of fact. I cannot see why on earth that he would appeal and look for liability on a case like this, because there's no evidence that we actually served him directly while he was visibly intoxicated.
So is there any evidence that anyone other than Copacabana and Copacabana employees can sell alcohol at the Copa?
According to Giuliano, who owned the Copacabana, and to Mr. Hernandez, who was a security guard, Copacabana actually hired and brought their own bottle girls and waitresses, and they controlled the alcohol on that evening, okay? So it was pretty run the city that was serving the alcohol. I can tell you, if you look at the affidavit.
Counsel, stop. You run through that real quick?
Right.
But at the end of the day, I don't care who hired the girls. The bottom line is, what entity is the one supplying the alcohol?
You mean the
bottles
that owned
right?
the alcohol?
So that would be the COPA, because I saw nothing in the record that controverted the name of the group, the promoter.
Right.
That he said that he had no liquor license, so he could not bring alcohol to this venue. And I know of no establishment that sells alcohol that allows anybody else to bring in alcohol to sell
Listen,
and undermine their alcohol sales. That doesn't happen.
okay, and I understand that point, and I'm willing to give you that, okay? But just quickly, but quickly, on the punitive damages claim, it was abandoned, it was not raised in his brief, there's no merits. The punitive damages cases are exclusively awarded against the drivers, not the establishment. The spoliation relief was not specifically sought after. It was, he said, you know, because we didn't provide these documents that are not entitled to summary judgment, he didn't move in his notice of motion, nor did he ask for an adverse inference charge. The trial court can do that. I cited a First Department case at trial. The issue is not preserved. Thank you.
Thank you. You have 2 minutes.
I'm going to be under my time, Judge Manzini. I thought I understood my adversary to say that there were admissions that the bottle girls that Hernandez said that the bottle girls were employees of the promoter. That's just not right. It's 627 to 628, 637 to 639, 842 to 843. Hernandez, in his deposition, said all of the people were employees of the COPA, and there is no dispute, as you pointed out, that the only one who owned the liquor and the only one who could sell it would have been the Copacabana. I do have one other thing to say. I just thought about it when my adversary spoke. Just something for you to think about. When I was younger, I'm way too old now, but we didn't have table service, right? You got a drink, you went to a club, you could reserve a table, but a waitress would come over. That's not how it works anymore. So picture this scenario and just see how it plays out from a public policy perspective, because I'm just a lawyer. 4 kids go into a bar. They're 21. I call them kids because I'm old. And they have 6 bottles of Grey Goose vodka. They're completely sober. Within an hour and a half, they're bombed, and they have 4 more bottles. They're exonerated from liability because they were sober when they came in, when the temporal arrangement between them was that they were going to drink for 5 or 6 hours. I think that's a terrible idea to have, and I don't think it comports with the intent or what the actual dram shop law says. Thanks for listening to me.
Thank you. Saw versus Mayor's Office of Housing. You may proceed.
Thank you, Your Honor. May it please the Court. My name is Michael Konopka. I'm here on behalf of the appellant, Clarice Saw, with respect to the lawsuit that she brought seeking to set aside a determination made by the City of New York with respect to an application for the Build It Back program. It's been just about 10 years since Superstorm Sandy really surprised the City of New York and wrecked great parts of the city. And my client went and was involved with the Build It Back program, worked with the Build It Back program hand in glove for a number of years.
But counsel, the issue here is whether she filed a fraudulent application, right? In order to get benefits that were geared towards helping.
I respectfully
helping the owner occupants of the houses.
Right. I respectfully disagree with that determination, which was made by the city. The fact of the matter is, there was an extended period of time between when that application was filed in conjunction with an employee from the program. And there was a mistake made with respect to certain items were blocked off that indicated that she lived there. However,
those mistakes were deemed by the city to be fraud, right?
Right, they were.
Fraudulent.
Absolutely.
Fraudulent.
And the fact of the matter is that that was a form which was filled out in conjunction with employees from BIB in, I believe it was September 15th of 2013, or September 5th of 2013. There were subsequently many meetings between my client and employees of BIB. And in the course of those meetings, she also filled out multiple forms indicating that there was a tenant on the premises. So
Did your client supply a lease or rent checks or?
she did
or
not
any-
provide, she did not provide a lease
Any
or
indicia of tenancy other than 2 utility bills that fell outside of the relevant
Sure.
time period?
Sure, Your Honor. I mean, I think the point, if I may,
Oh, well, what were they? Because I didn't see them in the record.
I'm sorry, there was no lease, there was no proof of rent payments, because I think what happened here is that there was this period of investigation. The city gave her a preliminary approval, and then they gave her a final approval, but that final approval didn't occur until 2016. And at that point, the parties entered into a written agreement, and that written agreement has a merger clause. And the merger clause provides that this document consists of the entire understanding between the parties. So I think if the city,
Including the representation that it was owner-occupied.
whatever representations, discussions, whatever have you, I think the merger clause covers that. And we have to look at not what she wrote in 2013, but we have to look at what was in the reality of the situation at the time she entered into the grant agreement.
The reality of the situation is that she applied for reconstruction assistance for the Broad Channel property in Queens in September 2013.
Yes, Your Honor.
In her application, her eligibility was premised on the documentation that she provided that showed that she received a star exemption for a Westchester home where she lived, that she had tax returns at the Westchester home, that she got child care at the Westchester home, the child care being 1.25 miles from the Westchester home and 38 miles from the Broad Channel home. So what are we missing here? Tell me, what are we missing here?
Your Honor, what we're missing here is everything that transpired between August 16, 2016.
So you're saying that we should ignore all of the mistakes, as you call them, fraud, as they call it.
Yes, Your Honor.
Just ignore it and only deal with what was the factual circumstances at the time of the grant?
What I'm proposing, Your Honor, is that there was a contract that was entered into between
Counsel,
my
I asked
client.
you a very direct question.
Yes, Your Honor.
You are down to 13 seconds.
Okay.
So if you go through all of this, we're going to run out of time.
Go ahead. I'm sorry.
So I'm trying to be real clear. You seem to be arguing that we should ignore the fact that there was false statements on her application, that additional and then additional information she gave them tended to at least conceivably apprise them that she had a residence somewhere else, but that somehow that fixes the error from the inception?
Your Honor, my client repeatedly advised the BIB program that she had a tenant in the premises. And that occurred
Counsel, you are
between
ignoring the
2013.
fact that she was never a primary resident at this, and she said she was.
Yeah, she did.
And that is the basis of the denial.
But we don't know that. There is nothing, we don't know why the city entered into this agreement in 2016. All right? We just know that there was a contract that was entered into.
Why is that the relevant issue?
It's relevant, Your Honor, because
The issue is whether she filled out the form at the inception properly and correctly and truthfully.
well, Your
And
Honor,
based on the evidence, she didn't.
based on the evidence, she advised them that
After.
before the grant was approved.
Yes, but after the initial application.
Your Honor, the initial application was a mistake, and she advised them of this mistake, and in 2016...
Where does she
3
tell
years
them
later,
she's not a resident of this?
She tells them that there was a tenant.
That's not my
multiple
question.
times.
My question was, very clearly,
Yes, Your
when did she tell them that she was not an occupier of that home?
There is nothing in the record to
Okay.
indicate that she
And
affirmatively
that
told them
was
that.
required.
What was required is that the
No,
premises had to be...
counsel, stop. You're out of time. You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, my name is Amanda Abata, and I represent the city respondents.
Did Ms. Saw ever contact the administrators of this program and say, oh my goodness, I checked off the wrong box. I'm not an occupier of this house I own. I have a tenant there instead.
No, Your Honor, what's established in the record is that Ms. Saw, not only did she check off, it's undisputed that she checked off a box that said that the property was owner occupied at the time of Sandy. A few pages later, in the same application, it wasn't just one time that she said it, she made the representation in the same form 2 more times that she was the owner, or she was the primary resident of this Queens property at the time of the Superstorm Sandy. So that's one. And when this whole thing led off with it, because the city's Department of Investigation got a complaint that she was not a primary resident of the Queens property. That led to an investigation. Subsequent to that investigation, we sent her this notice of the intent to default because part of the grant agreement was that she would not misrepresent her eligibility for the Sandy rehabilitation.
So did the notification that your office received that she was not an owner occupier, did that happen before or after the grant?
It happened after the grant agreement.
Okay.
Your Honor, and so we sent her a notice of the intent to default. What's relevant here that I would like to bring to this court's attention is that Ms. Saw's subsequent response back to that notice of intent to default stated that she, not only that she had a tenant, but that also that she lived there. So she doubled down, essentially, on this representation that she was a primary resident of that Queens property at the time of Superstorm. And then she said, of course, also that she had a tenant, but she provided no sufficient corroboration under the program guidelines to support that.
I'm sorry, did I read this incorrectly? But she would have been eligible for assistance had she just been honest from the beginning and said she had a tenant.
If she had if she had stated that, yes, and had proof of it,
right,
she would have been eligible for the funds under the program. But she didn't have proof, one, that it was owner occupied at the time of the storm as a primary resident, or that she had a tenant at the time of the storm. She didn't have proof of either of those things.
Just to piggyback on Justice Manzanette, Daniel's question relating to the agreement, how do you respond to your friend's point that the August 2016 agreement contained a merger clause and that therefore that should have represented the entire understanding between the parties?
In 2 ways, Your Honor. Specifically, I want to bring to the court's attention, of course, that this is an Article 78. This is not a hybrid claim. So I would say that this is also the wrong venue to allege any sort of relief under the contract. But specifically, the contract also speaks to the fact that there are penalties, and one of which is that the funds would be rescinded and Ms. Saw's contribution forfeited if she misrepresented her eligibility for this program, which she did.
Counsel, I guess part of the adversary's argument is that although they frame it as a mistake, that in essence, she told the city that she had a tenant before they went into the contract.
Your Honor, the city acknowledges that there were some forms where she put her alleged tenant's name, but those forms weren't properly filled out. They didn't have they weren't properly filled out. They weren't necessarily signed where they should have been. But secondary, the forms by themselves, without the corroboration under the program guidelines, don't establish primary residence. And she had and I just wanted to speak also to her procedural due process claim. She had the city gave her the notice of the intent to default. It gave her the opportunity to respond. She elected to submit a written response as opposed to coming in for an in-person hearing where she could have been represented. She elected to do a written response, and the written response, all she submitted was an unnotarized affidavit, where she was calling it, and those 2 old utility bills. And there's nothing in the record that establishes her residency, residency at the Queens property at the time of Sandy as a primary resident, and there was nothing that established a tenancy for her alleged tenant at the time of the storm during the superstorm.
Yeah, those utility bills were pretty interesting because one was from May to December of 2011, and the other, sorry, from May 2011 to June 2011, and one was from December 1st to December 30th, 2011. But when did the hurricane take place? When did the superstorm take place?
The superstorm took place in late October of 2012.
So all of these two one-month bills were deemed adequate or inadequate?
They're definitely inadequate. At minimum, she needed, you can't really use utility bills to establish a primary residence for a tenancy under the program, but to the extent that you could, you needed 6 months of them.
And they predated the superstorm by a lot.
9 months and 16 months.
Thank you.
I rest on my brief, thank you.
You have 1 minute.
Your Honor, I just want to make it, Your Honors, I just want to make it clear that on page 127 of the record, my client advised the program that she had a tenant at the premises. There's also on page 128 through, that one was in October of 2013. She notified them again in a form which was provided to her by BIB that there was a tenant in the premises on April 28th of 2014. And again, on June 20th of 2014, she advised, and the BIB program had actual knowledge that this tenant resided in the premises. The BIB program rejected my client's efforts to provide information without them ever telling her what it was she had to do. This is why it was arbitrary and capricious and why it was a lack of due process. We're putting the onus on you, but we're not going to tell you. We're not even going to come this close to telling you what you have to do, even though we've been working and guiding you through this entire program. So she provides information. She provides what she believes is an affidavit, and they reject it because it's not notarized. Tough luck. You're out $600,000. Goodbye. That's arbitrary and capricious. They should have at least given her an opportunity to rectify whatever errors there were in her submission after the letter of September, and they just didn't do it. Thank you.
People v. Jose Torres. You may proceed.
Thank you. Good afternoon, Your Honors. My name is Hillary Dowling, appearing on behalf of the appellant Jose Torres. We are asking this court to reduce Mr. Torres' sentence of 15 years prison with 5 years post-release supervision in the interest of justice.
Are you kidding?
I'm sorry?
On this case?
Yes, Your Honor.
With these facts?
Yes, Your Honor.
He stabbed the man 20 times.
That's, again, Your Honor,
And being in a drunken stupor is not an excuse.
And Mr. Torres is not suggesting that that's an excuse. It's merely a factor
So
that
what is it that warrants reducing his sentence after stabbing a man 20 times to death?
Well,
so by 2/3 of his sentence.
I'm happy to answer that question, Your Honor. Okay. First and foremost, and importantly, going to what Your Honor is pointing out right now, Mr. Torres does not dispute and never has the serious nature of his crime and its consequences. However, the nature of the crime is but one of many factors that this court can consider in determining a just sentence.
He does dispute his culpability, right?
No, I disagree with that assertion.
I don't know. He tried to withdraw his plea. He attacked the element of intent, although incorrectly. It doesn't seem to me that it was a very sincere attempt at being apologetic or contrite about what happened here.
Well, I'm glad you raised that because I did expand significantly on that point made by the respondent in their brief and my reply brief. The full record, as I laid out in my reply brief, I think makes very clear that Mr. Torres became focused on the fact that he did not intend to kill the complainant, which is entirely consistent with the plea to
Counsel,
manslaughter.
please.
Yes.
He stabs him once, maybe I could accept that argument. He stabbed him in the head, through his eye, in his kidney. I mean, in his chest. His lung was...
Your Honor, that's in the context, that is in the context of him being severely, severely intoxicated. Again,
Counsel,
not an excuse.
wasn't there an argument between him and his roommate?
Yes.
And didn't that argument come about because the defendant tried to sexually foist himself upon his roommate's girlfriend?
That was mentioned in some police reports. That's never been expanded upon beyond that being mentioned in the police report. But the fact is that both the complainant, the decedent, and Mr. Torres were heavily intoxicated at the time, which is supported by the people's own evidence. And I do want to be clear, that does not absolve him of responsibility. It is not an excuse. It provides context to the situation, which is an aberrational event in Mr. Torres's life. I want to go back to just the issue about the motion to withdraw the plea. I think the record makes clear that as he is trying to express remorse for the family, that he tries to convey that he didn't mean to kill the complainant, which I think is a very natural thing to do while expressing remorse and is consistent with his plea to manslaughter. His reference to being intoxicated and in a fight with the complainant, again, was to explain that he did not intend to kill the complainant. Again, consistent with what he pled to. And it's clear that during the colloquy with the court, it's very convoluted. Mr. Torres 3 times tries to say, no, I want to plead guilty. I'm guilty. I don't want to withdraw my plea. The court keeps going on, somewhat conflating the intent elements of the 2 crimes. And in his pro se motion that he filed at the next court date, everything he says in that motion is that he may not have been convicted of intentional murder. It clearly establishes that he was confusing what he pled to and thought that he had allocated to intending to kill this man, which was not the case. So I don't think that in any way was reducing his remorse or absolving himself of responsibility. I see that my time is up. I was going to briefly address the appeal waiver if Your Honors don't have further questions.
Thank you.
Okay, thank you.
Have a good day.
You too, thank you.
Velez versus Mitchell.
Good morning, Your Honors.
Good morning.
Martinez Jackson on behalf of Appellant. I would like to introduce my co-counsel, Jamar Creech, is an attorney barred in the state of Maryland. His Pro Hoc Vici application has already been accepted by the court.
His application, your application to accept him is granted.
Thank you, Your Honor.
I will spare you the speech of our colleague, Judge Mazzarelli, that we have over 100,000 very fine lawyers in New York, but welcome to our abode. You may proceed.
Thank you, Your Honor. May it please the court. As my co-counsel said, Jamar Creech on behalf of the appellant, Dagoberto Velez. Your Honor, Dagoberto Velez was not just a talent scout for the Ultimate Rap League. Point of origin is very important in this case. As the record shows at page 13, plaintiff was approached in 2009 to be a partner with the Ultimate Rap League, with the respondents approaching him to do so. The record also says, on or about October 26, 2009, the Ultimate Rap League began its operations in New York as a general partnership. Now, what happened here was the company started to grow and to grow and to grow. And
Counsel, let me interrupt you. Where does the amended complaint speak of the sharing of losses in the partnership? What chapter and verse,
Certainly, Your Honor. With respect to the sharing of profits and losses,
And specifically with an eye towards why the added statements are conclusory and insufficient.
So the complaint at, one moment.
And we're using the amended complaint, correct?
Yes, the amended complaint.
Why are the allegations that were added there insufficient as conclusory?
Your Honor, that's, we disagree with the court because in 2019 alone, Mr. Velez put in $50,000 worth of capital contributions to host events on behalf of the Ultimate Rap League. And there's nothing in the record that says he even got that back. So the court
Sir,
is
a contribution analogous to a loss?
not necessarily, Your Honor. I would say a contribution's capital, but it can lead to a loss if that is not, if that investment is not returned, at least at that amount or greater, which would be a profit.
So I have to say that looking at the briefs and going through the record, this appears to be a very sad situation, to say the least. But we not only have what's purported to be an oral partnership agreement, but as my colleagues say, there appears to be no indication that there was an agreement that Mr. Velez would also share in the losses if the partnership took a hit. And that's the part that's missing. So if...
And it seems to be undermined by other things your client says with respect to if they needed to raise capital, et cetera, et cetera. He goes on about that, which seems to suggest that there wasn't real formality with respect to these essential elements of a partnership.
Well, Your Honor, as general partnerships go, I think that there may be instances where there isn't necessarily formality. I think that's...
Yeah, but, right, there's no formality, there's no written contract.
Absolutely.
That's an example, right? But you and I agree to do something and say, all right, we're gonna share in the profits, but we're also gonna share in the losses, okay? Is there any allegation here that that was the agreement between these parties, that that was stated clearly, and that that was the understanding that they were operating under?
Well, I think the inference that can be drawn from the complaint, and that's...
You were here when we were talking
I
about
understand,
inferences earlier.
I understand, Your Honor, and just liberally construing the complaint, the expenses that Mr. Velez paid for on behalf of the Ultimate Rap League were central to their operation. So it wasn't...
But again, that's capital. That's not losses.
Right, and you're absolutely correct, Your Honor. I guess what I'm saying is that in order for us to even get to the point of establishing what losses were, we would need to go to the discovery process, and we're being cut off here because...
But why wouldn't if there were losses to the partnership that were shared by all the partners, we don't need discovery. Your client should know what those losses are.
I think that's...
Unless he wasn't truly a partner and wasn't privy to all the goings-on of the business.
I see my time is up, Your Honor, so I'll take my seat.
Smart man. Next.
Thank you. May it please the court, James Cimitero, prior Cashman. I think the court has actually hit, well, let me take one step back.
I think you should.
Yeah.
Don't assume anything from the questions on the first half.
Why I'm retreating, Your Honor. From URL's perspective and from the perspective of the respondents, there's really two issues here, and the court's only seemed to touch upon the second, and that may be where you want to focus, but I'll nonetheless proceed. In our mind, the first question and the gating question that should be answered is, should the court even consider the amended complaint? And the answer to that from our...
Well, the court below already did.
Well,
that horse has...
Yeah.
That train left the station.
Okay, Your Honor, and I'll stipulate to that, and
I realize I'm belling into a cannon, I'm not going to persuade you, but if I may just, if you do actually look at the order, the second of the dismissal orders,
We always do. I love it when lawyers say that.
I'm sure you have, and I apologize
Okay.
if I'm being presumptuous or assuming that you did not do something. But it does say for the reasons stated on the record. And when you actually look at the hearing transcript, what the court says is, I'm not going to rule on the proprietary. I'll accept it as the operative complaint. However, it is improper. You have procedural mechanisms under the CPLR. You could have sought to replead. You could have sought to re-argue. Or you should have appealed. They did
Counsel,
none of that.
could you just focus on the real issue?
Yes, I may. Yes, of course. So to answer, I think, where the court was going. So now to the second issue. So if we considered the amended complaint, which the court seems like it will, have they stated any of their causes of action? And the answer is they have not.
This guy is working and developing your business out of the goodness of his heart?
Well,
he did this just because he likes you guys. Come on.
Well, I would say that all employees, first of all, I think...
He's an employee now?
No, he's an independent contractor, but all employees, all independent contractors, they all add value. They all add a service that helps benefit a company.
And they don't do it for free, right?
Keeping in mind, there's no allegation that he wasn't paid for his services. I understand there's allegations that he wasn't paid for all of his services, but to be a partner, to look at the essential elements, and the First Department has ruled on this many times over, you have to have shared intent, you have to have an agreement to share in profit and losses.
Counsel, isn't there evidence that he was held out publicly to be a partner of URL?
Is there allegations of that? Is that was the question?
Evidence, however you want to put it.
Well, there's certainly no evidence of it. I believe he said that they told him he was a partner, and those are in claims that were dismissed.
And what about the YouTube interviews where other partners referenced to him as being a partner of URL?
I don't believe there's ever the use of the term partner, and I believe even if the term partner was used as used in the colloquial sense, I believe it says is we're the members here, this is who URL is. But
well, as your friend pointed out in his argument, this is a 3211. We have to view the pleading in the light most favorable to his client.
Sure.
And so if there are inferences to be drawn from something, we should be drawing them in his favor, not in defendant's favor.
Well, granted, I would stipulate to that. But I would say, though, even if I said that someone is my partner in a colloquial sense, it doesn't relieve them of pleading the elements of the cause of action. You ask them point blank, where in your 442-paragraph complaint did you say that you shared losses? He never. Keep in mind, this is a 10-year factual predicate. He can't identify one instance over 10 years where he shared in losses on a startup that, by their own account, made no money. It's not there because it didn't happen. And it's
why are his allegations at 345, 346, and 347, paragraphs 345, 346, 347 of the amended complaint at this juncture insufficient? Where at 347 he says at the meetings, which he referenced in the prior paragraph, that where we would talk about profits and losses, at the meetings, plaintiff and defendants agreed to share profits and losses from events equally.
So if you look at the First Department's prior decision in Slavicus, that is a conclusory allegation. And I think it does bear relevance here that in the first 15-page motion to dismiss, Judge Oscar...
How else would you assert that? If that was indeed the agreement, if that actually happened, and I wasn't there, I don't know, but if that actually happened, how else would he be able to put that forth other than the way he has? Since there's no writing.
Well, respectfully, there's 10 years of practice here. You could point to one example where there was a manifestation of that agreement. I think the real critical part...
But you're saying that the plaintiff would have to prove that there was loss as opposed to stating or showing that there was an agreement to share loss. What happens if the entity was really doing well and never had a loss? Doesn't that run counter to what you're arguing?
Under that factual scenario, I'd absolutely agree with you. I would say, however, the allegations are that it was an unprofitable enterprise and that the enterprise did not make money. That's according to the allegations. If I may, just to get back to your question,
in your motion for summary judgment, did you put forth evidence that that URL has suffered over the last 10 years some losses that only your clients paid for and that the plaintiff here did not participate in? Did you put anything like that as evidence in your motion?
Yeah,
The summary judgment.
just to ground this, we're still at the dismissal stage, so it was,
Counsel, I asked a direct question. The answer to that question is yes or no.
we've never gotten to summary judgment, so the answer is no. This is on a motion to dismiss, Your Honor.
Yes, but you have to establish that you are entitled to summary judgment, and you said yourself they haven't established that they would share in losses.
I
A
think,
way of establishing that would be to show that you, only you guys paid the losses.
I can certainly say the discovery has borne that out, but we have not filed a motion for summary judgment. We're not seeking summary judgment. What we're seeking is that this court confirm the 2 orders of dismissal. And I do think it's really important. You did ask, and I do want to answer this question, in paragraph 259, the question that was asked is, what did you share? Did you share in the profits? And if you actually look at the complaint, paragraph 259 is quite illuminating for the amended complaint. What it actually says is, well, I shared in the proceeds of some of the events, not all. If you're a partner, you share in all of the profits.
Thank you.
Thank you. Appreciate it. Thank you, Your Honors.
Counsel, you've got 2 minutes.
Thank you, Your Honor. And just to address that point really quickly, the actual paragraph 259 actually says, would share profits when made available for some of the URL events, specifically Born Legacy and Proving Ground events, going back to the point of what the court just said, every event may not have been profitable, so you can't assume that every event was profitable. There may not have been profits at every event, so it wasn't talking specifically about losses, it was only dealing with profits in that instance. So,
Sir, how do you answer your friend's argument that under count 5 of your amended complaint, the allegations with respect to shared losses were quote-unquote conclusory?
I don't think they're conclusory because this was more or less a decentralized operation. Your Honor, there were instances where Mr. Velez ran events pretty much himself, so the respondents could not even determine or state with any degree of certainty what came out of those particular events because they didn't have as much of a role in those particular events. So I don't think it's conclusory because for those particular events, he can absolutely speak to those. And there are other events where he may not have as big of a role. So the truth lies somewhere in between. And that's essentially what we're talking about in terms of getting to discovery and where we're kind of being cut off at this point.
Thank you.
Thank you so much, Your Honor. It was an honor to appear before you today.
Thank you. New York Presbyterian versus New York City Water Board. You may proceed.
May it please the court, my name is Amanda Abata and I represent the city appellants. This court should reverse the lower court's decision because respondent failed to comply with the rate schedule's procedures for administrative review. The Water Board's rate schedule sets forth a generous 4-year time period for initiating an administrative complaint. And respondent failed to challenge their water bill within that 4-year timeline as required by the Water Board's guidelines. The rate schedule puts forward a 3-step process for formal complaint and appeal. The first step requires that a written complaint be sent to the Department of Environmental Protection's Bureau for Customers.
Of course, what the New York Presbyterian is saying is that they were diverted to the ombuds process and that they didn't understand that that was not a proper appeal.
Yes, Your Honor.
And is it clear enough in the materials that you have like the ADR way to go, or you can do our normal appeals process?
Your Honor, they do make the argument that they were diverted from the normal process, but I would submit that that's undermined by the fact that they corresponded with Ms. Baird, who was operating with them with regards to the fact that they have a hospital account, and she let's say she engaged in some informal bill dispute resolution. She stated in her May 2016 email that no adjustment was warranted, and then she specifically referred them to the formal review guidelines and the rate schedule. She pointed them to the specific section, and she did that in May of 2016, which gave them at least 3 months to read that section of those guidelines and to follow and to follow that process. They didn't do that. They waited until September of 2016 when time had run, and then they attempted to do an appeal of Ms. Baird's decision. However, that's a nullity. Like, they hadn't followed the first essential steps. Like, they sent Ms. Baird a letter attached to an email. All they had to do was send that exact letter to the specific BCS PO box, and they failed to do that.
And here, Counsel, the final water bill was issued on, I think it's August 7, 2012. They didn't contact Ms. Baird until April 13 of 2016, and then she responded to them on May 16.
Yes, Your Honor.
That's the timeline as you understand it, correct?
Yes, Your Honor. They waited 3 years and 8 months for some reason, and then they contacted Ms. Baird in April of 2016, and she responded approximately a month later, and she told them, one, no adjustment is warranted, which essentially, to the extent that they were relying on her for some sort of appeal, she effectively closed that door, and then she referred them to the formal appeals process under the rate schedule, and they failed to take advantage of that until time had elapsed.
Was she required, was Ms. Baird, how do you say it, Baird or Bard?
I call it Baird.
Okay. Was she required to say in her May 19th, 2016 letter, writing to me does not commence an appeal, writing to me is not part of the adjudicatory process? Did she say enough in her letter to give them notice as to what the proper process was?
I believe she did, Your Honor, because first of all, all of these inquiries might be justifiable if this was a layperson, but we're talking about a seasoned expediter, the water group, representing a pretty big hospital. So I think it's sufficient. One, I assume they deal with this a lot, but I believe that it's sufficient within Ms. Baird's email that she referred them to the specific section of the rate schedule, which I presume they're familiar with, but to the extent they're not, it's 3 paragraphs, essentially. If you look at it, the first part says very clearly, a written complaint is done either by sending it to a specific PO box or by using the customer dispute form. And to the extent that my adversary is going to come up here and argue that there was some other alternative, it's just not laid out in that rate schedule. And there's nothing in the rate schedule that says that there's a different path for hospitals or that communication with the Ombudsman unit somehow supersedes this formal process under the rate schedule. And I would draw the court's attention very briefly to a decision out of the second department very recently, the matter of Jamin Realty versus the New York City Water Board, where that court found that a communication with the Ombudsman unit doesn't constitute a formal written complaint under the rate schedule's formal guidelines. And I would ask that this court follow their guidance, or follow suit, I should say. And if there are no other questions, I'll rest on my brief.
Thank you. You may proceed.
Good afternoon, Your Honors. Jody Gerard for petitioner respondent. May it please the court. I just want to clarify some things, some misrepresentations. First of all, that May 2016 email by Ms. Baird, she was not referring the hospital to take any formal process.
She said, please refer to Part 8, Section 2 of the New York City Water Board Water and Wastewater Rate Schedule for the complaint resolution and appeal process. It couldn't be any clearer.
That's right, Your Honor, but she was referring the hospital to the appeals process there. And we know that because later on in the record at page 127.
Complaint resolution and
appeals process.
Counsel, you are ignoring the first part. Complaint resolution. That goes before the appeal.
Yes, Your Honor, but later on, after being turned around, the hospital agent had to follow up.
Why were they turned around?
Because of
this is not the first time that the hospital gets a water bill, right?
Yes, Your Honor, but there is an established procedure within DEP, whether they would like to admit it or not, that hospital complaints are submitted to Ms. Baird.
Counselor, what I'm hearing you say is because they accommodate Large institutions like hospitals, I would imagine the same thing is true for universities and other huge institutions, perhaps the courthouses, right? That they have a special way that you can communicate on a quick issue that you may have to, let me finish, that you may have to resolve. But there is a clear process under the Water Board to resolve these issues. Are you saying that these large entities have special rules just for them?
I'm only saying specifically with hospital complaints that DEP has an established procedure as to hospital complaints. Ms. Baird even confirms this when she emails June 2016, and that is page 169 of the record. In response to an unrelated complaint that has nothing to do with hospitals, she wrote, "Unless this case is a hospital, please follow the normal procedure and address your concerns to the correspondence unit." And that shows at least two things. Ms. Baird is actively enforcing DEP's established specific rule regarding submission of hospital complaints. And it also shows what it looks like when Ms. Baird rejects a misfiled complaint. She does not
So
address...
counsel, I think that perhaps there's a confusion between Ms. Baird's role as a liaison so that large institutions wouldn't have to, make a phone call and stay on hold like the rest of a lot of human beings do for a long time in resolving a problem. How does that correlate? How does her role correlate with the actual complaint resolution and appeals adjudicatory process? She doesn't, as far as the record shows, she doesn't play a role within that. She is, as my colleague was saying, she's there as an accommodation.
Well, Your Honor, that is actually another point that I want to clarify, that Ms. Baird was not addressed as an ombudsman. She was addressed as someone who has been answering the hospital complaints for DEP for the past 10 years. That is a procedure that has been in place for a very...
Even the term ombudsman or ombudsperson or ombuds, that's the person you go to when you're stuck, right? That's not an adjudicatory process.
Yes, Your Honor. I don't know how long Ms. Baird has been ombudsman. I do know that she has been addressing these hospital complaints for over 10 years. Even if you look at, and that's also one other point, it was not just an email with a letter attached. There's a certified mail envelope that contains the April complaint at page 125 of the record. It's addressed to DEP's Bureau of Customer Service at the attention of Ms. Baird, not to the Ombuds unit. This was a letter simultaneously sent with the complaint to Ms. Baird because there has been an understanding and a rule established by DEP where hospitals submit their complaints to Ms. Baird, and even her own representations confirm that.
So here's the hard part. If the person with whom the hospital or its representative, the water group, has been communicating and working with for 10 years says, please refer to Part 8, Section 2 of the rate schedule for the resolution process, why wouldn't you listen to her? Why is what she's telling you, not you, of course, but why isn't what she's telling the hospital and its representative discounted, ignored?
I will submit that communication looks ambiguous, but she and the hospital understood that she was referring the hospital's agents to the appeals process because she later confirms that. She says, please continue to follow the appeals process. And she also says sorry for the inconvenience. She understands what's happening with the confusion, but there has been no clarification from Ms. Baird. There's no affidavit from...
The only clarification that was required was that somebody pull this section and read it and follow it. I mean, it's not your fault, but whoever was in charge dropped the ball here. They dropped the ball. They just dropped the ball, okay? You have an accommodation, that's great, but now if you want to file a complaint, you have to file the complaint the way everybody else does. And when you do it in written form, they very clearly lay out there are 3 ways to do it, and your people didn't follow any of them.
I see what you're saying, Your Honor. This has been the way it has been for over a decade, this established procedure with submitting hospital complaints to Ms. Baird. And the hospital's agent understood Ms. Baird, and she also understood because even during the appeals process, she never treated that April complaint as untimely. But
I got
yes.
it. I got it.
Thank you.
All right. Counsel, you have 2 minutes.
Your Honor, very quickly, I just want to draw the court's attention to a few things. When in that May 2016 email that Ms. Barrett sends to the water group, I want to highlight that she doesn't refer them to a specific subsection. She refers them to the entire section. So it's not that she said, now follow the second process, the city appeals, and disregard the first step. So I want to highlight that for the court. And then secondly, all of this talk about all of this hospital procedure, there's virtually no evidence of that in the record. Right, the record has no evidence that somehow whatever this correspondence with Ms.
It seems like they were always able to resolve their issue with Ms. Baird, and this is the first time that they were going to have to appeal something. That's the only thing I can garner from the way this happened.
I would say there's no evidence in the record of that, and maybe that could be the
That
case.
doesn't hurt you, by the way. I'm just saying that I could see why this could end up this way. If they had always succeeded in resolving their issues with Ms. Baird, right, then I could see how they would think, okay, this is how we're supposed to do it.
Well, maybe informally, and maybe without that May 26th email where she refers them to that formal procedure. But she did refer them to that formal procedure, and a plain reading of it without any sort of legal degree, but I assume the hospital had attorneys.
Case in point,
There's nothing about that formal process that says that somehow it's diverted or superseded by the fact that it's a hospital account or by dealing with the Ombudsman unit.
Right.
So.
Thank you so much.
Thank you, Your Honors.
People versus Jeremy Sanchez. You may proceed.
Thank you. Good afternoon, Your Honor. May it please the court. Erica Sweeting, appearing as pro bono counsel from Boy Schiller Flexner on behalf of Jeremy Sanchez. Your Honor, today I would like to focus on 2 main points: the lack of reasonable suspicion for stopping Mr. Sanchez and the improper jury selection process, and if there's time, the excessiveness of the maximum 25 years to life sentence. Your Honors, this is a case where a 16-year-old was stopped by an officer lacking any reasonable suspicion that he committed a crime, and where the trial court judge later flouted a Court of Appeals decision, directly reversing.
Your argument is that in light of the statements that there was shots fired, a van that stops, multiple people exit the van and run. The arresting officer here sees the defendant along with another person running. At some point, they stop, continue to walk. The officers instruct them to stop. They do. That's not reasonable suspicion. That doesn't amount to reasonable suspicion to investigate further either the shooting or the fact that the van was stolen?
Well, Your Honor, at the time that the second officer who received the radio call, he didn't know at the time that the van had been stolen. So it's important to separate the different facts.
You still have the shots fired, right?
Correct. The 2 facts that Officer Abramson, who was the one that stopped Mr. Sanchez and his partner that he was walking with, at the time that he stopped them, he had only knew 2 facts that came from the radio call. One, that there were shots fired in the vicinity, and second, that the direction of where the group of individuals were running. And so it's our contention today that based off of
that's what they had from the call, but then from their own observations, they had them running. They had them stop when one of the officers testified when presumably they made the cops, right? And you had those additional facts as well, right?
Correct. And in terms of what Officer Abramson knew at the time that he stopped him, that's correct, Your Honor. However, the fact that they were running is innocent behavior in and of itself. There's case law within this department. And
I agree. If that's the only thing, that's right.
That's correct. that at the time that Officer Abramson stopped Mr. Sanchez and the individual he was running with, they only knew of those two facts.
There were no descriptions given of the people running, so
Correct.
based on that, anybody who was running on this particular street on that particular moment, according to this police officer, it was justifiable to stop them if they were running.
Correct, based on these facts, just for simply being in the vicinity of gunshots. And Your Honors, it's our point today, not only that the conduct of running when there are gunshots in the vicinity gives no rise to reasonable suspicion, it's also our contention that the radio call itself was too vague to identify any criminal conduct. In other words, gunshots and running in and of itself does not give rise to criminal conduct that would have then supported a reasonable suspicion stop.
Well, one would think that gunshots would give rise to running, right?
If gunshots were happening, I would run too, Your Honor.
I would.
I think it,
What time did this happen?
3 o'clock in the morning. And my second point, since I see that I have 2 minutes left, I wanted to get to the improper jury selection process. Mr. Sanchez was denied a fundamental right to a fair trial where the lower court imposed improper time restrictions. And in fact, it was actually this very judge's conduct that was reversed by the Court of Appeals.
We're familiar with that, counsel. Is the record sufficient, though, to determine how long the voir dire by respective counsel was?
In terms of specific time, no, Your Honor. And what we are basing it off of is the fact that the record demonstrates that after about 4 or 5 pages of transcript, that there were specific points that the judge there decided to stop or give 1-minute warnings and then proceed with the stop. However, in defense counsel's objections during the voir dire process, it can be inferred that the time restraints were close to around 5 or 6 minutes because each time he objected.
It does seem to me that most of the people or probably all the people who had problematic pedigrees did say they could be fair and impartial. Now, your argument is the counsel should be allowed to probe that, correct?
That's correct. And particularly the holding in Stewart, which as you mentioned the court is well aware with, is that the issue is that the attorneys have to be able to get into the topics that are context specific. And here we have sensitive issues, just as with People v. Stewart, where you have a juvenile who was arrested, he was 16 at the time, and you also have the issue of a confession, which this court widely knows. Those two together, and I see my time is expiring.
Continue.
I may finish your question, finish your answer. With those two facts together, coupled with the fact that you are imposing improper time restriction, it doesn't allow for the defense counsel to really probe those issues and determine whether or not there's any biases in any of the prospective jurors.
Thank you.
Thank you.
Good afternoon, Your Honors. Excuse me. May it please the court, my name is Sheila O'Shea. I represent the respondent on this appeal. On the reasonable suspicion point, I would argue that the totality of the circumstances certainly supported the court's finding that there was reasonable suspicion for the stop. First, as
what's the totality of what are the circumstances?
well, the totality is we've got shots fired. We have that reported by a police officer as opposed to an anonymous tipster. Almost simultaneously, within a minute, Abramson, when he receives the radio run, drives over, and at precisely the moment he would expect to see the males running, based on the radio run, he sees so that's number one. Number two is you've got the defendant and his companion looking over their shoulder as the police car is following them, at which point they stop running and slow to a walk, which I would argue suggests that was a method to avoid detection. But I
could you see, I mean, I
beg your pardon, I'm sorry.
There have been cases, and I've written on this issue before, that being afraid of the police and looking over your shoulder if a police car is following you is not reasonable suspicion.
But that's not all there was, Your Honor, and I think as my adversary has neglected to point out, we have the officer, Gregorio, observes the defendant holding his waistband when he's running. That is a telltale sign of possessing a gun. I mean, at that point, I think it's game over. Now, furthermore, after the stop, you have the defendant lying to the police. Abraham says to him, why are you running? He says, I wasn't running. Abraham.
How do we deal with the fact that although he was holding his waistband, as you say, they found no gun?
Well, because he was only subject to a pat-down. It's not inconceivable.
Counsel, a pat. Did they find one later?
They did not, but...
Okay, so that means that the pat-down revealed he had no gun.
But at that moment, I think it was reasonable for the officers to conclude he's running from the scene of, he might have been one of the perpetrators of the shots fired. It was reasonable to conclude that.
Okay, why handcuff him?
He wasn't handcuffed. First of all, the testimony is inconsistent on that point. Abraham said he didn't remember handcuffing him, and Shulman said initially when he arrived on the scene, he saw the defendant with his hands on the ground behind his back. And on cross-examination, and when the defense attorney said, was he handcuffed, he said yes. But even if he was handcuffed, I think there was no evidence flowed from the illegal hand, to the extent there was handcuffing. No, there was an intervening event of Shulman, I beg your pardon, yes, of Shulman showing up to make the show of identification, which gave rise to probable cause. So as I've argued in my brief...
Counsel, what I would like to ask is, the defendant being handcuffed, let me ask another question. When was the defendant arrested here?
The defendant was arrested...
I don't mean the time, I mean at what event?
He was arrested after Shulman made the show-up identification.
So, if he was handcuffed before Shulman got there to make the confirmatory identification, was the act of handcuffing him, did that elevate the investigatory stop into a full-blown arrest?
No, it didn't, because...
How do you square that with the case of people Blandin?
Well, the people had two, I beg your pardon, the police here had two bases on which, if they did, to handcuff. One is the risk of flight, and the other is the potential for danger.
Well, what's the risk of flight here? I mean, yes, he was running, but he slowed down and he followed police instructions.
Well, except he lied to the police. So he didn't follow their instructions entirely.
No, he did follow the instructions. That he lied about why he was running, that's one thing. But they told him to stop, and he stopped.
Okay, but then also, again, I would argue that there was the danger from the potential of having a gun in his possession.
But
that
they
danger
searched him.
Right, the danger, he was searched.
Okay, well, let me go on to my next argument, if I may, which is that it really doesn't matter. Certainly, they could have restrained...
No, it does matter, right? Because if we conclude that at the time that the handcuffs were placed on him, that he was under arrest, then the question is, what is the probable cause for that arrest at that time?
Well, it doesn't. I would submit that under this court's decision in Jordan, the linkage was broken between the supposed police misconduct and the evidence by the subsequent show of identification made by Shulman. That's exactly what Jordan said.
So what you're arguing is that the confirmatory identification by Shulman somehow breaks the causal link of an arrest that's done without probable cause?
That's essentially what this court said in Jordan, and Judge Manzanet herself was on the panel.
Yeah, but I was also on the other one that said that you have to have probable cause before you place someone under arrest.
As I said, first of all, he was only, to the extent, I'd like to argue that he wasn't under arrest because there was a short detention of less than 9 minutes. It was probably a lot shorter than that. The officers knew that Shulman was close by. He arrived within a minute or so. There was no other, the defendant wasn't interrogated. He wasn't taken anywhere. He was simply held there until Shulman can come over and make the confirmatory ID. And again, the record is inconsistent as to whether he was handcuffed at all. It could have been that Abraham said to him, put your hands behind your back as a method to restrain his movements. I don't think on this record we can say with certainty that the defendant was handcuffed. And again, I don't think it matters because of the break in the evidentiary chain. In other words, no illegality flowed from the handcuffing. The confession arose, the probable cause was established when Shulman came up and made the show-up ID. He would have made the show-up ID whether or not the defendant was in handcuffs. Now, if I may address quickly the voir dire point, may I?
We're out of time. I'll give you 30 seconds.
Well, it's largely unpreserved. The defendant didn't make any objection to the voir dire procedures until midway through the third round. There was no record of the length. So there's a Kinchin problem here. We don't, in fact, the record suggests that the defense, both sides were given 10 minutes in the first round because at the start of round two, the defense attorney says, I don't think 10 minutes is enough, I'd like 15. So on this record, I don't think the court can find there was, and furthermore, the court itself probed the—
Well, that's the problem, quite frankly. It just is. And I know the judge doesn't agree, but I disagree. Attorneys are entitled to do their own questioning on voir dire. It is not the court's responsibility.
But the attorney did do questioning here, and he questions.
Yes, with their hands tied.
Well, he questioned 4 jurors.
Counsel, this isn't a debate.
Thank you,
I've
Your
made
Honor.
my statement. Counsel, you've got time.
All right, thank you, Your Honor. I think my first point that I would like to address is with respect to Officer Abramson, and I think my opposing counsel is conflating the different steps that happen with each officer. It was Officer Abramson who made the stop. In between that time, all he knew was that there was gunshots and that there was individuals that were running. Then at that point, he called another sergeant who then said that that the vehicle was stolen. And then at a separate time, Officer Schulman made the ID. So if there's any causal link that is purportedly broken, which we're not saying that there is, there's no exact link between Officer Abramson and Officer Schulman who made the ID that would have given rise to probable cause. And then second, I disagree with the contention strongly that it was a telltale sign that the individual grabbed his waistband. That conduct in and of itself it could have been anything. He could have grabbed his waistband because he was adjusting his pants. And that point was later vitiated by the fact that there was a pat down that revealed no gun. And if I can just finish my last thought on that
30 seconds.
Okay, actually, I would actually prefer to address the jury point that she had brought in her. With that point, it's not fair to say that that the defense counsel didn't provide the opportunity to object. He first objected in the first instance during the first round of questioning. Even in the third round of questioning, he spent 5.5 pages of transcripts with a thorough objection on the record. And even the trial court judge said, your objection is noted, you'll take it up on appeal, and invited this court's intervention by directly asking us to appeal her finding. And if there are no other questions, I rest on my papers. Thank you.
Thank you. McKeon versus State of Robert McKeon. Versus Ramsey, sorry.
Your Honor, Rachel Fritzler on behalf of respondents. Having heard the court's statement earlier, I would nevertheless respectfully like to move the court's permission for my partner, Brian Seavey, to argue this.
Your application is granted, and I'll spare you the speech. Welcome. You may proceed.
Thank you, Your Honor, and may it please the court, Joshua Polster on behalf of the appellants, the estate. The trial court erred by dismissing the estate's complaint. It interpreted the contract contrary to this court's precedent and disregarded the estate's well-pleaded allegations. I'll focus my argument this afternoon on the two ways in which defendants breached the contract by taking $200 million in value out of Veritas and distributing that $200 million in proceeds among themselves to the detriment of the estate. First, Section 4...
Counsel, with respect to the loan, the credit and guarantee agreement identifies the borrower as manager, correct?
Is the manager, that's correct.
So the manager's going to have to repay that loan, correct? At some point. Okay, but who got the 200 mil, actually, I'm sorry.
The $200 million was distributed to the defendant, the three principals.
And those folks don't have to repay, right?
That's correct, Your Honor.
So they're getting proceeds, correct? That's your argument.
Also correct, Your Honor.
All right, please continue.
And so Section, Your Honor's question was addressed to Section 4A of the contract, I believe, which specifies that the estate is entitled to 10% of proceeds relating to a sale of equity interests in Veritas. The estate's
Counsel, just a question for emphasis, I guess. The proceeds, are they defined in 4A as net proceeds or gross proceeds?
The contract just uses the word lowercase proceeds. There's no specificity as to net or gross, nor under this court's precedent is that is proceeds a term of art that is automatically net or gross. It depends on the factual circumstances, and I would submit to the extent that is a question here, it's subject to the facts and circumstances, which should be decided on a record following discovery. The estate alleged in its complaint how the $200 million in proceeds were related to the equity sale. In fact, that the sufficiency of those allegations is not disputed.
Indeed, the agreements refer back and forth.
That
The
is
omnibus agreement refers to the loan agreement and vice versa.
that is absolutely correct, Your Honor. The equity agreement, the loan agreement refer back and forth. They were referred to by the same deal name by the parties, closed simultaneously, and many more items of overlap. It was part of one transaction by which the principals leveraged the sale of equity in order to take $200 million in value and distribute it amongst themselves to the detriment of the estate.
Counsel, a contract should not be interpreted to produce a result that is absurd or commercially unreasonable. With that in light, is it unreasonable that the plaintiffs would get that the plaintiffs would want their percentage of that $20 million when they don't? I'm sorry, $200 million when they don't have an obligation to repay back that loan the way that the manager does?
No, Your Honor, because as Justice Moulton identified, the manager has the repayment obligation, but the principals who received the money don't have that obligation, and the estate doesn't have the obligation. And what ultimately, this is a breach of contract case, and the contract says proceeds relating to a sale, and our allegations are sufficient to show that relationship. Secondly, under Section 6, the estate has a right of consent to actions that would materially adversely affect the interests of the estate as reasonably determined by the estate upon prior notice. As alleged, and it's undisputed, there was no request for consent for the estate for this loan and payout, and the estate did not consent to the loan and payout. And our allegations alleged how this $200 million loan and payout adversely affected the estate by taking value out of Veritas, lowering the price paid by Dial, and therefore lowering the amount remitted to the estate, and also depressing the value in connection with future transactions. The contract delegated to the estate its own reasonable discretion if a transaction adversely affected its interests. Our allegations in the complaint are more than sufficient to show the estate, in its own reasonable view, would have found this to be a materially adverse effect. Its consent was not requested, its consent was not given. That is sufficient to state a claim under the contract.
And during this process, you attempted to exercise Section 8 and get more information on the deal, and that was not provided, just one term sheet.
That's correct, Your Honor. We requested certain information under Section 8, received some, but not all, then sent a follow-up letter requesting information. There was no response. Then a letter was sent to the estate after the deal closed when it was a done deal. Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Brian Seavey on behalf of the respondents. Your Honor, let me start with the estate's claim that it is entitled to be paid 10% of a $200 million loan. Justice Schechter correctly dismissed that claim because she found the contract was unambiguous and because the term proceeds, as a matter of law, did not include a loan that Veritas had been taken out.
Nowhere in the very detailed omnibus agreement does it even discuss any of this, right?
Well, it does in some respect, Your Honor. What it says in Section 4 is that the state is only entitled to 10% of the proceeds relating to a sale of interest in the manager.
And that's what this was. They sold an interest in the manager.
And they got every dime they were entitled to for the sale of the manager. If I could explain, I wanted to answer a question that was raised by the panel on my friend's argument. The loan was an advance for salary, bonuses, and carried interest payments that are due to the principals in the future. And so it is not correct to say that the principals do not have to repay that. The manager repays it, but those are amounts due to the principals. Justice
So
Schechter,
how does if the manager, if the agreement says that the manager has to pay it and not the principals individually, how do you put that that donut in that square peg?
Because the principals are waiving their rights, Your Honor, to future salary, bonus, and carried interest payments.
Now,
And Justice Schechter recognized.
Counsel, I'm sorry to interrupt you.
I'm
Just,
sorry,
just
no,
one little fact. The loan was not payable until 2030 at the earliest, correct?
At the earliest, yes,
Okay,
correct.
thank you.
But Justice Schechter recognized this factor in oral argument because she asked the same question to my friend on the other side. Isn't it correct that these are amounts that are going to be repaid essentially by the principals as advances on carried interest, salary, and bonus? And the answer is
It's
correct.
the essentially that you just used. This is a pleadings motion. And so why isn't it sufficient at least to plead that these were proceeds related to a capital event?
Well, because, Your Honor, what the court below found, which I think is entirely correct, is that it makes no economic sense. The plaintiff's theory here makes no economic sense. If you accept their theory that they're entitled to 10% of a loan, the principals are worse off than if the transaction had never occurred, because they have to pay the $200 million back, plus they have to pay interest, plus they have to pay $20 million as 10% of the proceeds. So they are worse off under this interpretation, and she rejected that because that is not a commercially reasonable interpretation of the contract.
Sir, I'm sorry.
Yes.
What effect, if any, did the Veritas's incurring of the $200 million loan have on the value, the estate's value of Verista?
The estate's value of what, Your Honor?
Their interest in Verista.
In Veritas, I'm sorry.
Veritas, I'm
yes,
sorry.
okay. I don't think it had any impact on that, Your Honor, because
How is a debt, counsel,
if
come on
I
now.
may.
A company is assessed based on their balance sheet, right? And if you have debts on a business, that reduces the value of that business by that debt.
No dispute on that, Your Honor. But the theory that the plaintiffs were advancing is that somehow the company would have been sold for a higher dollar amount absent the loan. And that's just, first of all.
Well, we don't know that. And I have to tell you, I was just shocked by the respondent's brief in this case to attempt to suggest that a company such as this, that had the kind of money of investments in their portfolio, would just collapse from day to night, and that they would not have other potential buyers to sweep in and take over such a profitable fund is kind of ridiculous on its face.
I think you're referring to the fact when Mr. McKeon passed away, Your Honor.
Mm-hmm.
Well, I think the fact of the matter is that when Mr. McKeon passed away, that absent the principals taking control, that the fund would not have been able to continue operating.
Someone clearly had to take control, but that they were the only people in the universe that could do it?
Well, I'm not sure we intended to imply that.
Yeah,
Your Honor.
well, the brief goes pretty far at attempting to imply that.
Well, if I may just make a final point here. This court has repeatedly said that you have to interpret contracts in a commercially reasonable way and avoid formalistic literalism. And that's what Justice Schechter did. She recognized that it makes no sense commercially to say that the plaintiff is entitled to 10% of a loan that has to be repaid with interest. It turns the economics completely on their head.
Counsel,
And-
your adversary said that the principals received the proceeds without the obligation to repay. Did I misunderstand?
No, that is not correct. If he said that, I don't
Did
think
I
that's correct.
misunderstand? Or
Well, I'm not sure if he said that.
He did say that.
Okay. The manager is obligated to
Right, the
repay, and the
manager,
principals own the manager, Your Honor. So the principals are required to repay it.
And this
Through the manager.
and this litigant has an interest in that manager.
An interest.
And to the extent that the value of the manager is reduced, their interest is reduced.
Well, but Your Honor, it's no different, if I may. It's no different than if the equity transaction had occurred, and then a week later, the principals had gone out and borrowed $200 million, let's say from JP Morgan Chase, and said, we want to use this as an advance. They could have done that, and they have no right to object to that. And because they have no right to
Because there would have been no argument that the money that they were attempting to use was their money.
No, but it would have impacted the equity value of the company, Your Honor, in the same way. That's the point. And this is what Justice Schechter identified, any transaction theoretically affects the equity value of the company. I mean, taking out a lease for a new property, taking out a loan in the ordinary course, all of those have an impact on the equity value, but that's not what they're entitled to under the contract. Under the contract, what they're entitled to is 10% of the proceeds of a sale. Not a loan, a sale. And the proceeds mean what they
And the loan was a part of the sale and was related to the sale.
Related to.
That's the problem you have. That's the problem. At
Unless-
this stage. You might overcome later, but at this stage, that's the problem you have.
Thank you, Your Honor.
You have 2 minutes.
Thank you, Your Honors. Just briefly, several things that my friend mentioned. He focused on proceeds as a matter of law, that finding by the trial court. That was error. This court has frequently used the term proceeds to describe amounts received in connection with a loan. Further, defendants' own correspondence to the estate, their own transaction documents all talk about the $200 million as proceeds. So a finding that as a matter of law, the $200 million could not be proceeds on a complaint as a matter of law, that was error. Secondly, my friend focused discussed the concept that this was effectively an advance of salary because ultimately if Veritas, the manager, had to pay it back, ultimately would affect compensation to the owners, the principals. That hypothesis, I mean, that is outside the record. That's not, the transaction documents are, this is a loan that burdens the manager to the detriment of my client, the estate. This idea of commercial reasonableness, at a minimum, that is something that should be decided on a full record of discovery. It cannot be decided and construed against the estate on a complaint. One should look at the drafting history. One should understand what is the commercial reasonableness in the context of this transaction of the private equity industry. It cannot be construed against the estate on its complaint.
Also, do we get to commercial reasonableness? First we start with the language of the contract first, and first there has to be ambiguity before you even consider commercial reasonableness, or am I overstating that?
Agreed, Your Honor. In our view, the contract unambiguously favors the estate, but if one were to find any kind of ambiguity or bring in commercial reasonableness, it should be on a full record, not construed against the estate on a complaint.
Well, if there was an ambiguity, presumably there'd be extrinsic evidence about the meaning of the terms in addition to any canons of construction that might inform the meaning.
Yes, Your Honor, and that should come in following a discovery record. If there's ambiguity, then extrinsic evidence should come in.
You're out of time. You have anything else?
Nothing further, Your Honors. I thank you for your time.
Thank you.